Okay. Yeah. Yes, so good.
Good morning, Mr. Mybeck. Good morning, everybody.
Good morning, Chairman.
Good morning. You may be seated, Mr. Mkwanazi.
Thank you.
Thank you. Are you ready, Mr. Mybeck?
Yes, thank you.
Yes, okay.
Mr. Chairperson, I've just received, I think what is referred to as a supplementary statement or affidavit, which I understand Mr. Mkwanazi wants to hand up, obviously with your leave. It's a short document, it's about 5 pages long. It addresses the things that he accepted were outstanding. We personally don't have any objection to its introduction. The Secretariat is in the process of making copies and will add it to the bundle at tea time. In my submission, it needn't hold up the continuation of the questioning of Mr. Mkwanazi.
Yes. No, that will be in order. But in the meantime, we can continue.
Thank you. Good morning, Mr. Mkwanazi.
Good morning, Advocate Mybeck.
Morning.
When we broke on Friday evening, I was questioning you about the 2 bits of advice you received from the NACE rates or advice with their input, that being the memorandum of the 15th of February, followed by their report on the 22nd of February. These are 2 bits of advices that came either side of the board meeting on the 16th of February. Do you remember that?
Yes, I do.
Perhaps I could just take you to that advice. If you turn, please, to bundle 2.
Yes.
And if you could turn up page 13, that's the memo of the 15th. And then, as you know, at page 19 is the report of the 22nd, correct?
That is correct.
Now, I just ask you to confirm that your evidence was that the first bit of advice, in other words, the memo of the 15th, if my notes serve me correctly, your evidence was that you accepted that that memorandum and the advice was poor. Is that correct?
Yes, I did admit that it was not thorough. It was poor, yes.
Would you accept then that on the face of it, when you say it was poor and not thorough, it certainly wasn't persuasive?
Certain aspects of it were persuasive, but if a better analysis could have been done, it would have been a better advice, for instance, yes. But that analysis was not very clear at the time.
And it was on that basis, if I understand your evidence correctly, that you asked the NACE rates, and the word that you used was to augment their advice. Is that right?
Yes, Chairman, I think we did, because even as a subcommittee and board, when we got that initial advice, we were not impressed.
But then why did you follow it? This is what I don't understand. Why did you think it was appropriate, having received a piece of legal advice that you weren't persuaded by, why did you allow the NACE rates the opportunity of augmenting it after the board meeting of the 16th of February?
Chairman, we did allow Dennis rates, and also you'll have to understand that there were 3 issues that sort of Dennis Rates was trying to give advice on. and they didn't give advice specific to certain issues, which frankly would have been a better approach, where they should have taken the first matter, second matter, and third matter, and gave advice on the three almost independently. They somehow tried to give a summary advice on all three matters. And in my interpretation, the gravity of the three matters was not the same. But having said that, I don't have a serious problem with your advice, say, on the first two offenses, which relate to procurement. But I have problems with your advice on the third matter, which related to the attack of Mr. Gigaba on the executives and board of Transnet. But on the first two other matters, because don't forget at the time from where I said, the issues, the focus was on procurement, where the other irregularities, yes, the focus was on procurement. But I truly say that advice did not address the issues individually, and I suspect the outcome could have been different.
You suspect the outcome could have been different?
From the board as well.
Yes.
If the three issues had been handled specific.
But
yes.
Mr. Mkwanazi, really what I'm driving at is you get poor legal advice. It doesn't deal with everything. But you still take the decision on the 16th of February. You don't wait for the augmented legal advice, correct? Is that correct?
Yes, that's correct.
Right. So let's then go to this augmented legal advice.
I'm sorry, Mr. Maibek. Mr. Mkwanazi, you see, if on the 16th of February, you and the board realize that the advice from Denise Reis is poor advice, it needed to be augmented, and you don't wait for them to augment their advice before you take a decision. It gives the impression that you have made up your mind by the 16th, that irrespective of whether the advice that gets augmented or the augmentation of the advice puts the advice at an acceptable level in terms of its legal strength. You don't wait. When you don't wait for that, it gives the impression that you have made up your mind and it doesn't matter what the augmentation will produce. You are going ahead because you are clear in your mind that this is the decision you must take. Do you have something to say on that?
Chairman, I'm in agreement with your observation, but again, I need to sort of qualify it in that that advice, although it was almost a generic advice, was not thorough in dealing with the three matters separately. That advice was required on. On the procurement matters, that advice somehow I indicate that it could have been appropriate. But on the question of the attack on executives and the board, that advice said nothing about that. And I think,
yes,
as I indicated, it could have been oversight on the side of the board or not, particularly following up on that issue of the attack on the executives and the board members.
Mr. Maibek?
Yes, thank you. Now, just to go to this augmented legal advice that you receive on the 22nd of February, which you find at page 19. Mr. Mkwanazi, it also doesn't deal with all three charges. Correct?
Advocate, you are correct.
You still then don't go back to Denise Reis and say, but what about charge 3, or where's the analysis? All they do is they repeat the generic advice that they gave you before. Correct?
Advocate, my book, you're correct.
But why did you not go back to them? I mean, the truth is you had no sustainable legal advice. You had generic advice which didn't deal with one of the charges at all. Correct?
I agree with you, Advocate Maibeko.
And then there's a bigger problem. And that is, you yourself accept that Denise Reitz's augmented legal advice was contradictory. Correct?
I agree with you, Advocate.
But still, you don't go back to them and say, but hang on, I don't understand what you're actually saying. Correct?
I agree with you, Advocate, yeah.
It really bears out your desire and the desire of the board to reinstate Mr. Gama at all costs, doesn't it?
Maybe not, but as you rightfully point out, if ideally at the time or in retrospect, the board should have even sent back the second advice to say, hold it, you are still not specific enough. Yes, I agree with you.
But the board had already made up its mind by that time, on the 16th of February.
That is correct, Advocate, yeah.
So let me press you, if I might, in relation to paragraph 1.1 at page 20 of bundle 2.
I'm there, Advocate.
At paragraph 1.1, it says there are various opinions that have been obtained from reputable firms of attorneys with regard to prospects of success of Mr. Gama in successfully challenging his dismissal by the company. All the opinions, including ours, which we gave after perusing documents pertaining to the disciplinary inquiry, were of the view that Mr. Gama's chances of successfully challenging his dismissal are not good. Did you receive that legal advice from Denise Rhodes?
Yes, we did, Advocate, yes.
Yes. And then after that, did you receive the memorandum of the 15th that they gave input into?
No, don't forget, the memorandum of the 15th is earlier than this so-called augmented advice. Yes, yeah.
So, well, I'm not sure.
This was done on the 22nd, if I recall.
Yes.
And that other memorandum was prepared on the 14th or 15th of February.
Yes, but Mr. Mkwanazi, they're dealing with a history here. They say all the opinions, including ours that we gave after perusing the documents pertaining to the disciplinary inquiry, were of the view that Mr. Gama's chances of successfully challenging his dismissal are not good. Had you seen that advice?
I'm not sure if it was in the memo of the 15th, but I see what you are saying. Post the first memo of the 15th, then comes this advice on the 22nd. But their advice goes further to still create doubt that this matter in the Transnet Bargaining Council can go either way. Yes.
But here they say...
I agree with your assessment.
Mr. Mkwanazi, here they refer to an opinion where they said that Mr. Gama's prospects of success are not good.
I see what you are talking to.
You can't explain this. Was that in their memorandum of the 15th, or was it in some other document?
No, I don't recall, because their memorandum of the 15th, I'm not sure now what it said.
Well, just so that you understand,
yes.
Just to refresh your memory, remember the memorandum of the 15th? It was produced with the input of Denise Rhodes, but your testimony was that it was presented to the board or the committee as a memorandum from Group Legal.
That is correct.
So, had you seen a prior opinion from Denise Rhodes that said that Mr. Gama's prospects of success were poor?
I might have. I don't recall a specific one rather than this one of the 22nd, but on that one of the 15th of Feb or 14th of Feb, it then goes on to create doubt about whether we will win a Transnet Bargaining Council. But again, having indicated earlier that even that memorandum of the 14th or 15th of February was not specific to the three items that any unfairness could have been identified. It was not specific.
So I've got two more questions for you. Yeah, I've got two more questions for you before I move on here. Firstly, why did you not go back to Denise Rhodes and raise with them the contradiction in this opinion? At 1-1, they're saying, we've given you opinion saying his prospects of success are poor, and then in their conclusion, as you put it, they raised doubt. Why did you not go to them and say, clarify this, what actually are you saying? Why did you not do that?
No, at the time we did not do that, Advocate, yes.
Yes, but we know that. My question is, why did you not do that? It seems so obvious, doesn't it?
No, it does not.
And then, having specifically asked them to augment their advice, you say, because they didn't deal with the third charge, they don't deal with it here, you still don't go back to them and say, deal with the third charge, correct?
Yeah. No, we did not.
Why not?
We omitted that. No, we did not at the time, yes.
It seems the obvious thing to do, doesn't it?
Not really.
Well, Mr. Mkwanazi, please, just let me understand. You go to Denise Rates, you ask them to augment their opinion. Amongst the reasons that you want them to do that, you say, is that they don't deal with the third charge on 15 February. They then provide an augmented opinion and they still don't deal with it.
They still don't deal.
Are you suggesting to the chairperson that you didn't think it was the obvious thing to do, to go back to them and say, you haven't done what I wanted you to do?
We did not do that on the 15th of February, yes. And even on the 22nd, we did not go back to them and say, but you have not dealt with the third matter in terms of the issues that you're supposed to deal with.
And you can't explain why you didn't do that?
No,
All right.
I know we did not go back here.
Did you and the board, when you were dealing with these matters, with this Gama matter, remember that there was a charge which had got nothing to do with procurement?
That is correct.
You did remember?
No, I'm aware, yes, Chairman.
Yes. Yes, no, I'm talking more then rather than now. You were aware at the time that there were 3 charges for which he was dismissed.
Chairman, at the time, the focus was on the procurement issues. The focus was not on the last matter of the attack by Mr. Gama on the executives and the board. The focus was on the procurement issues. And I think it was an oversight of the board not to have focused even on the third matter and just thought that the procurement issues were sufficient to deal with this issue in a particular way. It was an oversight.
Would you agree that it would appear that it was that Mr. Gigaba, if your evidence is true, may have also suffered from the same oversight, because when he, on your evidence, instructed you to review Mr. Gama's case, he doesn't seem to have said anything about the third charge. He talked about condonation and procurement.
No, Chairman, your analysis could be correct, but I assume that Mr. Gigaba is also going to come and have his say, and also Mr. Gama is going to come and have his say on these issues.
Yeah, no.
I would sense that what you are saying is true, Mr. Chairman.
Yes, no. Mr. Gigaba will come also at some stage and give evidence. Okay. Thank you, Mr. Maibek.
Thank you, Mr. Chairman. Could you please go to the draft settlement agreement?
I'm sorry, Mr. Maibek. Of course, Mr. Mkwanazi, is it not remarkable that so many people in the board overlook, if it was overlooking, something so important to say, why are we not talking about the charge that has got nothing to do with procurement? And Denise rates, the attorneys also seem to lose sight of that. Why are they not? Why is there not a single person in the board who says, but hang on, We are talking about reinstating Mr. Gama on the basis of condonation, but condonation doesn't apply to the other charge. What do we have to say about that?
Chairman, your observation is spot on, but then I just need to highlight one small matter that at the time when this matter was being dealt with, the board's focus was on procurement and the perceived unfairness of how Mr. Gama was not afforded the other process of condonation. In other words, the focus was on the unfairness on the first two charges. And that is why even maybe at board, no board member then said, hold it, but it's not only these two issues. There's this other major issue, which was the third charge of him attacking the executives and the board. Yes, the board neglected that angle. And in hindsight, the board somebody should have said, hold it, but these are not only the two issues that we're dealing with. Yes, these are procurement, but here's this other one of attacking the executives and the board.
Yes, you see.
It was not raised by any board member at the time.
Yes, you see, it is exactly that I'm asking you about, whether it's not remarkable. Namely that despite the fact that Mr. Gama had been dismissed for 3 charges, despite the fact that the board had available to it detailed rulings of the chairperson of the disciplinary hearing, which made it clear there were 3 charges, and that one of them didn't have anything to do with procurement. Despite the fact that the board had available to it Mr. Todd's opinion report, which made it clear that there were 3 charges, one of which had nothing to do with procurement. Is it not remarkable that the whole board left out this particular charge, which had got nothing to do with procurement? It is it not?
It is, Chairman, it's a serious oversight
Yes.
by that whole board, and I admit that it was a serious oversight.
Yes. Of course, somebody analyzing this or listening to the evidence relating to Mr. Gama's reinstatement and so on, somebody might say, well, it was oversight, and that's it. Somebody else might say, maybe it was oversight that happened because the board was too keen to take Mr. Gama back, and that's why they overlooked something so that was right there in front of them. Maybe somebody might say, you see, they'd found what they believed was an answer to procurement. There was no answer to the other charge. So focusing on this other charge would spoil the arrangement now. Because if we don't have an answer to this other charge, how do we take Mr. Gama back? So let's focus on procurement. You want to say something, Mr. Mkwanazi? To the various scenarios I'm saying people listening to the evidence might think about.
Chairman, your observation is correct, but as I indicate, that board, for some reason, I hope other people will come in and actually give more information on how the environment, the atmosphere, etc., on this matter was, because particularly on procurement issues, there was a strange perception that maybe Mr. Gama was targeted because there were certain similar, although they're not similar, in terms of procurement, there might be. But this other last charge, frankly, was something unique, and maybe the first time that that board should have looked into at the time to say, yes, there are three issues. Two are procurement. One is this attack on the executives. Unfortunately, Chairman, at the time, that board did not focus on that matter because it focused on procurement issues, thinking that there was no consistency in the organization in dealing with procurement.
I see that almost all the members of the board who deposed to affidavits and that have been given to the commission say they were not aware of any role played by anybody outside of the board or outside of Transnet in the reinstatement of Mr. Gama. But Mr. Mapoma did say there was pressure that was put on him by Mr. Siyabonga Mahlangu, the special advisor to Minister Gigaba. Of course, Mr. Mahlangu has denied that he put any pressure. You did not have any pressure brought upon you to try and make sure that the board agreed to reinstate Mr. Gama.
I wouldn't call it pressure. Yes, there was a request to review if the sanctions of dismissal were fair. That was by the shareholder. Yes, there was a request that we review the sanction of dismissal. And have I lost sound?
No, we can hear you.
Then, having said that, that is why then I think even when we looked at alternative advice, the shortcoming of the advice we got, it did not deal specifically with the three issues, as the advice from Mr. Todd did deal with the three issues. Now, therefore, the advice that we used from Dennis Reeds came with almost a general recommendation, which I must say was not the best advice, because they should have said, you've got chances with 1 and 2, but you've got no chances with 3. Then that board, I doubt if it would have come to the same decision.
Of course, you know, the advice from Dennis Reeds, one has got to go back to it. As I recall, it doesn't deal, for example, with the issue of condonation, if I recall correctly. It says we have previously given an opinion that says Mr. Gama has no good prospects of succeeding in his dismissal claim, unfair dismissal claim. But then later on it says there is a probability that the bargaining council or a court, considering the appropriateness of the sanction of dismissal, may reach the conclusion that that dismissal was not appropriate, having regard to the challenge on sanction advanced by him. And then I think the earlier one tells you about the one of the 15th tells you about different cases where courts can come to different views on sanction. So I don't know whether your recollection is different, but my recollection is that they don't seem to talk about condonation, the Dennis Reeds. Is your recollection different?
Chairman, yes, they don't talk about, they're not specific. That's why I say in hindsight, it was not the best advice. because they should have dealt with the three issues, and also they should have dealt with even this condonation matter as advisors, because condonation at the time did not necessarily imply that then you are free from any potential disciplinary action post-condonation, because my understanding even of that condonation policy, there must be consequences for the fact that you even go to an extent of requesting condonation. Why didn't you do your homework properly before? Yes. But yes, the advice from Dennis Reeds was not the best advice.
Yes. Mr. Mybeck?
Yes, thank you. So, Mr. Mkwanazi, what you've accepted is that it was, as you put it, a serious oversight on the part of the board not to consider the third charge on the 16th of February. And you say if the board had done so, its decision might very well have been different, correct?
I fully agree, Advocate.
Is that correct?
That's correct, Advocate.
But what I don't understand is you knew of the shortcoming because you went back to Denise Rates so that they could augment their opinion in respect of the third charge. That's your own evidence. You see the contradiction?
Advocate, maybe let me try and... we felt that as a board, the advice we had got on the 14th or 15th of February was weak. And therefore we said augment it. And funny enough, even after augmenting, they came back with what I can call weak advice, because they did not deal with the specifics of the three issues and the possibilities of winning at Transnet Bargaining Council or losing at Transnet Bargaining Council. So yes, they did not touch on particularly the third matter of an attack on executives.
But Mr. Mkwanazi, perhaps you aren't following my question. It wasn't an oversight. You identified the failure and you asked Denise Rates to address it. When they didn't address it, you just pushed on in any case. It wasn't an oversight. On your version, you identified the failure.
Yes, that is correct. I don't know whether it's failure or weakness of their submission. I would call it more weakness because it did not deal with, my understanding, if you deal with, I want advice on this issue, and these are the three issues, then the advice should have addressed the first issue, second issue, and third issue. And the Dennis Rates advice didn't even articulate the three issues.
But then why did you not go back to them when they didn't address the failure or the weakness that you had identified?
Chairman, at the time, the doubt created of winning or not winning at Transnet Bargaining Council sort of played a prominent role in us making that decision then.
Why didn't you and the board take the following position? We as the board know that we have received 3 opinions, legal opinions from 3 reputable law firms. And they all say, we have a good case. Mr. Gama has a poor case. They say Mr. Gama's has no reasonable prospects of winning this case against Transnet. Having got those 3 opinions from 3 different law firms, we have one of the law firms which gave one of those opinions, saying in this legal advice, there is probability. They are coming up with something that seems to go against what they have already said. And what they are saying is not persuasive this time around. It's not substantiated. Let us stick with the position given by 3 different law firms, namely, we have a good case and Mr. Gama has a poor case. We have good chances of winning. Let us make our decision based on that. Why didn't you and your board take that position? Why did you take a position that is supported by a legal advice that contradicts legal advice that was given previously by the same law firm, that is now weak, that goes against what has been given by 2 other law firms and by itself? Why do you choose a position that is not supported by sound legal advice when you know you do have the benefit of sound legal advice?
Chairman, as I might have indicated in the past, we did get good sound legal advice from a number of legal firms, including Mr. Todd's note. And at the time, we felt that, let's pursue, because we were trying to review the sanction. Then we indicated that let's then get a different law firm with different legal eyes, because my sense, by the way, based on the legal advice that we've had before, I doubt if the companies that were involved in the actual disciplinary process in Transnet would have come with a different legal advice. But yes, that be as it may, we felt that let's test if is there a different legal advice out there. Unfortunately, it came and it was not a very strong legal advice, because it did not touch on one of the key issues, which is not procurement related.
Wasn't that the problem, Mr. Mkwanazi? Namely,
Chairman.
Namely, I'm sorry, was that not the problem?
Chairman.
Oh, can you hear me?
Yes, I can hear you, Chairman.
Oh, okay. Was the problem not exactly that? Namely, that you and the board were looking for a different advice. You were not looking for another advice, which could be the same as the advice that had been given before by Bowman's ill-friend, Mr. Todd. So as long as you had not received a different advice, you would not be happy. You wanted a different advice. And when you got it, even if it was poor, you were happy to rely on it. Isn't that the problem? That you should not have been looking for a different advice. You could have been looking for a different law firm to give advice on the same issues that Mr. Todd had given and Weber Wenzel had given, but the advice did not need to be different from theirs. You should have simply been looking for another advice that need not be different. If it was different, fine. Then if it was different, you would compare its soundness with the soundness of the other advices that you had received. Do you understand what I'm saying? That maybe the problem is that you were looking for a different advice.
Chairman, what you're indicating could be true, but maybe let me retrace the process a little bit. On the procurement issues, the 2 procurement issues, the advice could have been different in that the so-called similar procurement irregularities in Transnet had not been considered when that sanction was determined on the first two matters. So on those first two matters, I do think that there was a need to get sort of a review of on the similar case matters relating to procurement. What was done? And these matters went back as early as 2005. So on those, there could have been a different legal opinion on review. But on the third matter, irrespective of whatever review you would have had, my sense is that review would have come out and said, on the third matter, the sanction is a fair sanction.
No, thank you. Before I let Mr. Maybeck continue, I just mentioned this. As I understand the position, Mr. Gama had raised the issue of condonation at the disciplinary hearing, had raised the issue of inconsistency at the hearing. Now, one of the issues which I think, if I'm correct in that, one of the issues that the board should have thought about was to say, why should we as the board get involved in reviewing Mr. Gama's case? And maybe that's what you should have said to Mr. Gigaba, maybe not on the day that he approached you, but after you had fully informed yourself on the case. Why should we as the board get involved in reviewing this case? Because Transnet has taken the trouble to offer to Mr. Gigaba a very fair process, which has got an independent chairperson. Transnet is has spent money paying senior counsel to sit as a chairperson in a disciplinary inquiry, so that Mr. Gama has got a fair process. Because if maybe it was one of the senior executives chairing his disciplinary inquiry, he would complain that it was not fair. We have paid for senior counsel to sit at the disciplinary hearing. And I take it that Mr. Gama did not contribute, would not have contributed to the cost of the chairperson. You know, those costs were borne by Transnet. The chairperson sat for 14 days hearing evidence. That's a lot of money. And apart from that, there would have been a lot of time that he spent preparing for the hearings and afterwards preparing those very thorough and detailed rulings that he prepared. You did all of that as Transnet, it might have been the previous board. That was all done in order to advance fairness and transparency. So, now, in that process, Mr. Gama was free to bring whatever evidence he could bring to the disciplinary inquiry to show that he had been treated unfairly, including the issue of condonation, including the issue of saying there were other executives who had done the same thing but had been treated differently. He had the opportunity of bringing those cases before an independent chairperson. He was allowed to be represented by his own legal team. I don't think every employee at Transnet gets allowed in a disciplinary inquiry to be represented by outside lawyers. But he was allowed. I'm not saying he was the only one, but he was allowed. Now, why didn't you and your board say, here is a very fair process and a very fair forum which has been provided to Mr. Gama. If he makes out his case there and wins, we as the board will accept that outcome and take him back. If he fails to make out his case in that forum, then we will abide. We'll give effect to that decision. Now he has failed in that disciplinary inquiry. He's going to the bargaining council. Even though that is called a Transnet Bargaining Council, it was still an independent body in the sense that the arbitrators who sit there are not employees of Transnet. They are independent lawyers. So why didn't you say, Mr. Gama has an independent and fair forum at which he can put his case. Let him put his case there, and we will abide by whatever decision. Why didn't you and your board take that principled position and say we are not going to interfere?
Chairman, I need to go back a little bit and indicate that there was a public protector letter around the 22nd of December I don't know the exact date, 2010. Now,
I think 22 December.
In 2010.
It's 22 December 2010 is the letter.
Yes, in 2010.
Yeah.
Now, in a way, it is that public protector letter which elevated the matter to the chairman's office. Your analysis is correct. But then once this matter was then elevated to the chairman's office, the company then had to respond to the public protector. And as part of that, certain allegations were made there. And as part of that response, the initial process was to appoint KPMG and Gonki to look into the facts now. And then they did, and for some reason, if I recall, their first draft report was sometime in January. But that draft report, as in retrospect, I saw the file on Monday once it was brought in by some staff members, on Friday, last week Friday, from the Zondo Commission. That first draft report did not contain the detail I thought it did in terms of dealing with this issue. But yes, what triggered the matter to go to board was the public protector complaint, if I can call it that.
Yes, but
and then it became sort of a board matter, yeah.
But even with that, I don't think that the public protector would have had any problem if the board said, with regard to Mr. Gama's dismissal, we have set up an independent forum and a fair process at which Mr. Gama is free to put his case as fully as he wants. He has done so. This is the outcome. He is now going to another independent forum. There too, he will have a process where he can make out his case. And we as the board will abide by the decisions of those independent fora. Why didn't you and the board take that principled approach?
Chair, at the time, as a board, we did not take that approach, yes.
Mr. Myberg.
Thank you, Mr. Chairman. Mr. Mkwanazi, please just turn to page 6 of Bundle 2, the agreement of settlement signed
yes.
in draft form, signed by Mr. Gama on the 10th of February, 2011.
Yes.
You have said that you were the lead negotiator. Is that correct?
That is correct.
So by the 10th of February, you had already, at least for yourself, decided that Mr. Gama should be reinstated as the chief executive of TFR, correct?
That is correct, Chair.
That, of course, was before the Denise Rates advice.
That is correct, Chair. But let me qualify that. You know, these things, when you look at them 10 years or 9 years later, there were other reports that were produced in Transnet, which were indicating, I'm focusing on the procurement matters, that there could have been some unfairness on the procurement issues. That is correct, Chair, yes. And still today, I don't have those reports, and hopefully one day they will surface.
Yes, but the point is that your evidence has been that you appointed Denise Wright to bring fresh eyes to bear on this issue. What you'll end up doing is deciding for yourself that the man must be reinstated before those fresh eyes produced any advice, correct?
That is correct.
But doesn't that bear out then, Mr. Mkwanazi, that really what you were looking for is legal advice that accorded with your decision? Correct?
You could be correct in indicating that, but yes, I got wrong legal advice at the end of the day, yes.
Isn't it so that you had decided to reinstate Mr. Gama even before you went to Denise Wright?
To say decide is too strong a word, but we were in discussions based on the information we had, even as early as the 1st of February, if I recall. I'm not sure what subcommittee that was, etc. We were in discussions on some form of review of the Gama sanction issues, yes.
But you have repeatedly told the chairperson that why you went to Denise Wright is you wanted them to bring fresh eyes to bear. It doesn't seem to me that you waited for their advice. You had already decided, certainly you yourself had decided, that Mr. Gama was to be reinstated before that advice.
It was a consultation process at the time, and with no final decision, because only around the 14th, 15th of February would then a final decision be taken by a subcommittee of the board and also elevated to the board.
Let me take you, please, to Mr. Mahlangu's affidavit.
Yes.
That you find in Bundle 1.
Bundle 1.
I'd like you to turn to page 170, 170.
170. Yeah, that's the one. Okay, thank you. Yes, I've got that.
All right, so on Friday, we dealt with paragraph 7 at page 170. I want to direct your attention to paragraph 6, and then I want us to read the two paragraphs together. At paragraph 6, Mr. Mahlangu says, I was not involved directly or indirectly in the settlement discussions leading to the reinstatement of Mr. Gama. The only insight I have on the discussions was when I was informed by Mkwanazi, the then chairperson of Transnet and acting chief executive officer at the time, that the company intended to reinstate Mr. Gama. So in that paragraph, he says, you informed him that the company intended to reinstate Mr. Gama. Next paragraph says, due to the passage of time, I cannot recall the exact reason for or context of my discussion with Mr. Mkwanazi. In other words, the discussion that you had with him when you informed him of Transnet's decision to reinstate Mr. Gama. Correct?
Yes.
That's what he's referring to. He goes on to say he conferred with me on a variety of matters in my capacity as special advisor. And then the next sentence says, I recall that during my conversation with Mr. Mkwanazi, now when you read the two paragraphs together, he's talking about when you informed him that Transnet had decided to reinstate Mr. Gama. I recall that during my conversation with Mr. Mkwanazi, I advised that it was prudent for Transnet to seek legal advice on the company's proposed course of action. We discussed a few options on eminent labour lawyers that he could consult. One of the names that came up was Mr. Sibugule. So what I want to suggest to you that when you read these two paragraphs, it seems to be Mr. Mahlangu's recollection, that even before you went to Mr. Gule, you had decided to reinstate Mr. Gama.
I wouldn't call that a decision. I would call that part of a review process which had been requested by the shareholder much earlier on. And also, if I do recall, there was some other information that I had seen in January, much early in January, on irregular procurement in Transnet, a number of cases. It was a matrix of an Excel spreadsheet, which indicated offenses by certain executives, etc., and condonations granted, etc., etc., and the amounts involved. But that information is not available. So, like knowing what the system information was at the time, I was aware that there was something not on about the fairness of the sanctions on Gama on the two procurement issues. That I was aware of. And then, of course, in discussing with the board, even before the 1st of February, the board was then made aware that I was in consultation with Mr. Gama on some of the issues that would have come out of his disciplinary process. But having said, I was in consultation. Even at that time, the consultation was more of the procurement issues. And therefore, that is why some legal eyes were needed into looking into these issues. And what is interesting, even these legal eyes did not focus on the third issue or the third offense of criticizing executives. Yes.
Mr. Mkwanazi, perhaps I could just ask you for a direct answer. Did you or
Yes.
did you not tell Mr. Mahlangu before you had even appointed Denise Rates that Transnet intended to reinstate Mr. Gama? Yes or no?
It intended to review, not reinstate.
So you didn't tell him this?
It's a strong word, to review.
But how does he get it so wrong? Reviewing and reinstatement are two completely different concepts.
It's a review because, yes, that review had been requested by the shareholder in October 2010. Yes.
Yes, you're simply
Not reinstate.
repeating your evidence. Do you remember my question? My question is, how does he get it so wrong?
I'm not sure. Mahlangu, he's coming, I assume, as well, to have his say at the Zondo Commission.
And then if we go to his emails,
Yes.
at page 178, I think you've
Page
told
170.
the chairperson as well that he got it wrong when he
Yes.
told the minister on the 18th of January that you were nearing a settlement. He also got that wrong. Is that
No,
right?
I got it wrong. Yes, he got it wrong.
I see. Were you say though that you were speaking to Mr. Mahlangu around this time. Is that correct?
That is correct. I'm not sure around which time exactly, but yes, I would have been talking to him.
And did you speak to him about Mr. Gama's reinstatement?
Not the review that had been requested by the minister, not the reinstatement.
Well, I think that's very important evidence. Did you speak to him about the fact that, on your version at least, the minister had instructed you to undertake a review of Mr. Gama's dismissal? Did you talk to him about that?
Yes, I think I did, yes.
Right. And if you go to page 181, there's an email from Mr. Mahlangu to Mr. Gigaba on the 4th of February.
Yes,
And he says,
Yes.
Dear Minister, my meeting with Chair, he's referring to you there, correct?
that's correct.
You had had a meeting with him about your negotiations with Mr. Gama and his position in relation to applying for the GCE vacancy, correct?
Phew. Let me take out that piece of paper. Group Chief Executive. Yes, please continue.
Well, you had had a meeting with him dealing with those two subjects, correct?
Yes.
Now, what gave rise to this meeting on the 4th of February?
I do not recall. Wait. I do not recall even the opening statement that he makes there. But if I do recall, at the time, we might have already advertised for the filling of the vacancy of Group Chief Executive, yes.
So, were you keeping Mr. Mahlangu apprised of developments in the light of the instruction that you got from the Minister to, as you put it, review Mr. Gama's dismissal?
I would have.
Is that what you were doing?
I'm not sure what he says that advertising was a mistake. It was not a mistake.
Sorry, my question, Mr. Mkwanazi, is where you...
Yes, I was in discussions with him regularly, yes.
Yes, but you were having these discussions with him in light of the instruction that you received from the Minister, you say, to review Mr. Gama's dismissal, correct?
Yes, that is correct.
And this is a discussion that you were having with the very person that suggested that you should appoint Mr. Sabugule, correct?
That is correct.
So let us go then, please, to the...
I'm sorry, Mr. Maybeck. As I understand what you are saying, Mr. Mkwanazi, and as I understand Mr. Mahlangu's email to his minister, it appears that the two of you, namely yourself and Mr. Mahlangu, had regular interactions about matters relating to Transnet, and that included discussions relating to the matter of Mr. Gama. Is that correct?
That is correct, Chair. From the perspective that, yes, the Minister had requested a review, yes.
The interactions that you had with Mr. Mahlangu, were they on the basis that he would convey to the Minister whatever you conveyed to him in regard to various issues at Transnet, including Mr. Gama's matter?
No, I'm not sure if he would, but if also I recall at the time, the focus of the discussions were not necessarily, they were related at times generally to state-owned entities, yes.
To state-owned entities in general?
Under public enterprises.
Yes, okay. So are you saying that a lot of the discussions that you had with Mr. Mahlangu related to state-owned enterprises under the Department of Public Enterprises?
Related to Transnet specific, but occasionally other SOCs, yes.
Oh, okay. Generally, the discussions related to Transnet matters, but sometimes they would also relate to other SOEs. Is that right?
That's correct.
Yes. But when you were having discussions with him relating to Transnet, was it on the basis that he was, so to speak, the conduit for him to pass on to the minister the updates or whatever you told him? You were not just telling Mr. Mahlangu in his personal capacity. You were telling him because he was special advisor to the minister.
When you say in his personal capacity, in a way, because he is special advisor to the minister, my understanding was that then he would brief the minister, because I never interacted with the minister a lot.
Yes, okay. Yeah. So the basis for your engagements with Mr. Mahlangu was that he would brief the minister on your discussions. Is that right?
That is correct, Chair.
Yes. Well, maybe you have answered the next question I was going to have, namely, with the minister and Mr. Gigaba having instructed you on your evidence to review the Gamma case, whether you subsequently ever had a meeting with him where you told him how far you were with the review process, either before it was completed or when it was about to be completed?
I do not recall sitting with the minister briefing him in detail on progress on the matter. The only person who would have been briefed is Mr. Mahlangu.
Yeah, okay. And he would have, your expectation was that he would then share the briefing with the minister?
That is correct.
Okay, all right. Mr. Mybeck?
Thank you, Mr. Chairman. Mr. Mkwanazi, I'd like now to move to the board meeting on the 16th of February.
Yes.
I want to start off.
Can you wait? I'm not sure if the page is correct. What pack is it?
I'll come to the minute in a moment. But I want to start off just by finding out from you precisely what was before the board at this meeting on the 16th of February. Let me start by asking you, was Mr. Todd's opinion before the board on the 16th of February?
I do not think so. I don't recall that that big submission of Mr. Todd serving on the board or even serving in one of the subcommittees. Yeah.
You don't recall that?
I do not recall, no. Because ideally, if it had, it would have been part of a bundle in terms of the board pack, and I don't recall how the board pack looked like at that time.
But Mr. Mkwanazi, you had received Mr. Todd's opinion, as I understand it. You had read it as well.
Yeah. My understanding, I had received it. If I recall, it was done on the 2nd of February and given to one of the group legal people. Yes, I would have received it, and yes, I would have read it.
Don't you think it would have been important for it to have served before the board then on the 16th of February? I mean, why didn't you ensure that it was there?
If I recall, there was a subcommittee before that board, and again, these minutes, ideally it would have served there, and also when I say served there, coming, say, from group legal, because we worked very closely with group legal at the time. It would have served in a subcommittee, yes, but not necessarily at board, no. Now that subcommittee, I don't know if I've got a minute of it, but if I do recall, there was a subcommittee before the board meeting of the 16th. There was a subcommittee.
So you would have you would have seen the affidavit from the company secretary who says that the Todd opinion was part of the board pack of the 16th of February. You've seen that affidavit, haven't you?
I've not seen that affidavit. Can you take me to it?
Could we go to bundle 1, page 15?
Page 15, bundle 1.
That affidavit, Mr. Mkwanazi, would have been one of the affidavits that were sent to you together with the letter that invited you to depose to your first affidavit.
Wait, let me now go
Yeah,
back.
maybe if I find the bundle first.
Wait. Page 15. Not sure which. Okay. Dated 16, a document dated that entitled, okay.
So 3 lines down at page 12, or paragraph 12.
On paragraph 12, yes.
Therefore, the said document, and there she's referring to Mr. Todd's report, and the draft settlement agreement were tabled for consideration before the board when the board authorized the finalization of Mr. Gama's settlement agreement. A copy of this report is annexed marked MPM6. Now, can I just take you to MPM6? That you find at page 42.
Page 42.
She's put up
Okay.
the board pack, it seems. Board of Directors meeting 16 February, 12:30 to 5, Royal Elephant Conference Centre, Centurion. And then you'll see that there was spiral binding on the left-hand side of Mr. Todd's report. You can flick through it. It goes all the way from 43 to 68.
To 68. Okay. Yeah, okay, to 68. I see it.
So is it still your recollection that the Todd
sorry,
report...
Mr. Maybach.
Yeah.
I'm sorry, I was still concerned about Mr. Mkwanazi's response that he did not get or see that affidavit of the Camera Researcher, so I was checking that. I will deal with it later. What pages? So I missed the page numbers you were referring him to.
Yes, the page number,
And the
Chairperson, I was referring to...
the bundle 1,
to Annexure MPM6. That is at page 42.
Yes.
And
One second. That is on bundle 1,
that is correct.
Okay.
And then Mr. Todd's report, Chairperson, goes all the way up to 68.
Okay.
So,
Yes, okay, I've got it now.
Mr. Mkwanazi, is it still your recollection, and of course you can only testify to what you remember, but is it still your recollection that the Todd report was not before the board on the 16th?
When you say was not before the board, I see it was before the board, based on this document,
Right.
yes. But I did not recall it anymore, but I had seen it before, by the way, before the 16th.
I think it's very important for the chairperson to know precisely what information was before the board on the 16th.
Yeah.
Now, I can take you to 2 affidavits by your fellow directors, Ms. Gigaba and Ms. Chepe, who both confirm, and you might have seen that, who both confirm that the Todd report was in fact before the board on the 16th of February.
On the 16th, yes.
Do you need me to take you to those passages, or would you agree with that?
No, I do believe that it did serve on the board of the 16th of February.
And you've seen those affidavits. I mean, you were given all of these files over the weekend, correct? You've seen the affidavits of Gigaba and Chepe.
Yes, what, Gaba? Oh, Ms.
Gaba,
Yeah,
Gaba, and,
yes, I did get them.
and
yes,
Ms. Jeppe,
yes.
yeah.
All right. So can the chairperson then accept, on the strength of the board pack and on the strength of what they say, that you then accept that the Todd report's before you on the 16th?
Yes, on the 16th, yes.
Now,
Okay.
you and other board members talk about legal advice that was before the board. Now, do I understand you correctly that what you placed before the board after the memos of 14 and 15 February was what Mr. Mpoma sent you on the 15th of February, further to the input of Denise rates, and you presented that memorandum as the opinion of group legal, effectively Mr. Mpoma's opinion. Is that correct?
That is correct.
So when we look at these affidavits and reference is made to legal advice, that legal advice, and correct me if I'm wrong, comprises the advice of Mr. Todd and effectively the advice of Mr. Mpoma. Is that correct?
That is correct. That is correct.
And you've accepted previously that the advice of Mr. Mpoma that you placed before the board,
That is correct.
where you say some doubt was created, was entirely in conflict with the advice that he gave the Corporate Governance and Nominations Committee on the 3rd of February, when he told members of that committee, including a number of your directors, that Transnet had a very, very good case, correct?
That is correct.
Right. You've accepted as well that as of the 16th of February, there was nothing before the board from KPMG stroke Nkonki. You confirm that?
That is correct.
What we have seen from the affidavits of Kaba and Chepe is that both of them say that you informed the board that you had a list of contraventions that were comparable to Mr. Gama's case. Neither of them say you introduced this list. They simply say that you informed the board of a list of contraventions that were comparable to Mr. Gama's case. Do you confirm that?
Yes, I do recall.
And you've given evidence, and I think I've taken you to the relevant prior extracts, where you seem to have talked about a list of 30. Is that correct?
Yes, that is correct.
And if I understand your evidence correctly from what you've said earlier this morning and previously, that really was a list of persons to whom condemnation, in relation to whom condemnation was granted. Is that correct?
It could have been a list of irregular procurement processes and also condemnations granted. That is correct.
So you had this list.
Now, when you say you had this list, at the time, frankly, there was a spreadsheet which had been developed, which indicated some of these irregularities and some of the condemnations granted, and in some areas not even granted for that matter, but with the notes that disciplinary action will be taken, etc., yes. Now, subsequent to that list would have been circulating sometime in January. Now, having, I'm also trying to find that list. I've not seen it since.
Yes, I'd like just to take you, please, to page, it's Ms. Gaba's affidavit, at page bundle 1.
Bundle 1.
That would be Gaba, eh?
Gaba, bundle 1, 224.
24.
For the transcribers, Gaba will be GCABA. 224, you said, Mr. Maipek?
224.
Yes.
I could please direct your attention to paragraph 48.2.
Yes.
She's here dealing with the board meeting of the 16th of February and says, the chairman furthermore informed the board that there was a list of contraventions that were comparable to the case of Gama. You see that?
That's correct.
Did you do that?
Yes, I did.
You told them that you have a list of contraventions that are comparable to the case of Mr. Gama.
Yes.
You didn't, on her version, you didn't share this list with your fellow board members. You simply told them that you had this list, correct?
That is correct.
Let us go, please, to page 785.
785.
This is Ms. Chepe's affidavit. She's also dealing with the meeting of the 16th of February. And at paragraph 37.2, I beg your pardon, I want to take you to 784.
784. Yes.
She also says at 37.2, the chairman furthermore confirmed that there was a list of contraventions that were comparable.
Yes.
So this is your list of 30. You say it was in the form of a spreadsheet.
That's correct, yeah.
And what did it show? What did it reflect? So you have 30 names.
It would have been a couple of transactions, whatever they were, and of course it would have covered a number of years, if I can use the word, maybe from 2005 to 2010. It would have covered the actual procurement, whatever that was, and the fact that it either exceeded the mandate or it was irregular. There would have been columns with some analysis, and it would have indicated whether condonation was granted or not granted.
Okay, so this is important, Mr. Mkwanazi.
Yes.
You have a list of 30 people. So you, from what you can recall, 30 names. Span,
yes.
just, if I can just summarize your evidence and then you can either agree or disagree. You have a list of 30 names spanning the period 2005 to 2010.
That's correct.
The list would indicate the irregularity, as you put it, where the mandate may have been exceeded.
Yes.
And then there was an indication of whether condonation was granted or not. Is that right?
That's correct. Yes.
Now, how were you, on the face of that list, in a position to tell your fellow board members that those contraventions were comparable to Mr. Gama's case?
They are not 100% comparable because Mr. Gama's case touched on 2 procurement issues and 1 non-procurement issues. But where it touches on the 2 procurement issues, they are comparable. But when it touches the third matter, where Gama now attacks the other executives. There is no similar case, to my understanding, that is on record. Yeah. So it's only on the 2 procurement cases.
But even there, you didn't know whether they were actually comparable. You thought broadly they were because they involved
Yes.
procurement irregularities, but you didn't know the detail of the 30, correct?
No, I wouldn't know the detail, no.
So you really weren't in a position, Mr. Mkwanazi, even to tell them in relation to the 2 charges that the contraventions on your list were comparable, were you?
In fairness, they are comparable from a procurement principle that certain things were not done according to the procurement procedure manual of the time. That's the only comparison, not the quantum and not a lot of other issues, but the fact that they did not comply with the PPM at the time.
So they were, at best, broadly comparable.
That's correct. But the third one was not even something that I would have submitted to the board in terms of comparability, because there was no similar case.
So I suppose what you should have said is you shouldn't have said that the cases are comparable. You should have told them, look, they're broadly comparable because they all involve, in some or other way, procurement irregularities.
I should have said that.
Yes, it's a different picture, isn't it?
That is correct.
Yes, all right.
I take it that you approached those 30 names or so where condonation had been granted on the assumption that the employees concerned would have applied for condonation. Is that correct?
Chairman, some of them did. That is correct, yes.
Mm-hmm. Were there some who had not, as far as you know?
Chairman, some had not, and for some reason, although they were in the minority, when those that maybe might not have applied, but nothing was done, etc., yes.
Mm-hmm. As I understand the position, condonation was not supposed to be had for the asking. Was that your understanding at the time as well?
My understanding, Chairman, is that you could ask for condonation. But when you say ask for it, you talk to your immediate supervisor about the issue, and in most cases it involves a Transnet internal audit. And you then talk to your boss about whatever you've done wrong. And then your boss can then decide whether through the necessary council that had approved that transaction, that the matter can go for condonation, or you must be disciplined or whatever, but it's through the approving authority who would have been your supervisor.
Yes, no, what I mean is that the position, as you also understood it, I understand the position to have been that just because an employee asks for condonation, doesn't mean that they will get it. It always depended on the merits of each request and the circumstances of how the irregularity happened. Is that correct?
Chairman, I agree with you, yes.
I also got the impression from some of the documents from Transnet that the idea was that condonation could be granted for non-serious irregularities, if I understood correctly, Maybe non-serious is not the correct term. I don't know whether it's non-material, I'm not sure. But I got the impression that there was a clear distinction made to say the more serious the deviation or the irregularity, the less likely that an employee would get condonation. Is my understanding the same as what your understanding was at the time?
Chairman, sort of, but the question of seriousness is not an easy one to get into, because
Yes.
how do you define the seriousness? Is it a 1 billion, a 2 billion? What's the quantum? Because some of these issues that eventually had to be condoned ran into billions of rands.
Yes, but leaving out the question of whether it was a good idea to make a distinction between serious irregularities and maybe not so serious irregularities, or material irregularities and non-material irregularities, leaving aside the question of whether it was a good idea to make that distinction, is it your recollection that there was such a distinction in terms of the policies?
Chairman, there would have been. I'm now trying to assume what. I haven't read the PM, the
Yes.
Policy Procedure Manual of Transnet in a long time.
Yes.
But yes, there would have been that, because I'm not sure where fraud comes in here, because some of
Yes.
these things could have been fraudulent.
Yes.
And
Yes.
also, I'm not sure where fruitless and wasteful expenditure comes in on these, because
Yes.
some of them would have been fruitless and wasteful. They were of different categories. Yes.
Yes. But would it be correct to say that the authority considering a request or application by an employee for condonation would have had to take into account, among other factors, the factor of how serious the irregularity was? Would it be correct to say that?
You are correct, Chairman.
Yes. Okay, thank you. Mr. Mybeck.
Thank you. Mr. Mkwanazi, just correct me if I'm wrong, but as I understand it, on this list of 30 people, some of those people, condonation had not been granted. Is that correct?
That is my understanding at the time, yes.
And if I understand your evidence correctly, the list might also have contained names of people who were actually dismissed for procurement irregularities.
My understanding, yes, it will have contained some people.
Importantly. And in fact, if I understand it, I think on Friday you talked about a list of 22, and then we've seen when Mr. Malefe was appointed, your affidavit says he was instructed to deal with 12. So can you remember how many people on this list, with reference to those figures that I've just given you, were in fact granted condonation? Wasn't all 30.
Maybe I need to sketch this scenario a little bit, because the question of condonation is a strange matter. Let me make an example of one particular contract where I got directly involved. It was the VAE contract. I don't know what the company name was. But the increase in amount, the issue was people who kept on paying a supplier on what was then an irregular contract. And that made the contract value increase from 980 million to about 1.8 billion. And where now the question of the number of people, in fairness, just that one contract alone, about plus minus 8 other people were involved in making these adjustments, where ideally some of these people should have called the process to a halt and say, hold it, but we're busy making payments against an irregular contract. I'm trying to indicate that when I say the number is 30, that contract alone would have had about 8, and another contract would have had a certain number of people. That is how people got attached to an irregular contract.
I think really I was just looking for a number because your evidence, you've spoken about 30, you've spoken about 22, you've spoken about 12. Are you able to help us with a number or not?
Frankly, that homework will have to be done because these numbers that you're mentioning, I don't have an exact number. Frankly, at some stage, while I was there at Transnet, we thought the number was even over 100. But through going back into the history of the various procurement irregularities, the numbers in January 2011 would have been about 30. And some of those numbers, interesting enough, are also calculated in the KPMG final report of November 2011.
Now, Mr. Mkwanazi, as I understand your evidence in response to questions from the chairperson, is that on the bare information that you had on the spreadsheet, you weren't able to identify or determine the severity of each individual case, correct?
Not at the time, yes.
But what we do know is that by way of comparison, you were in a very good position to determine the severity of Mr. Gama's misconduct. Correct?
Yes, yes.
And why is that?
Hold it, don't forget, Mr. Gama's matter is threefold. 2 are procurement and 1 is non-procurement.
Yes, but you were in a very good position to assess it. I was driving at because, of course, Mr. Todd had done that for you over a space of 25 pages, correct?
That is correct.
All right. So let us go to the minute, please, of the meeting of the 16th of February.
What pack is that?
The minute appears in various places, but the first time that was put up was by the company secretary. Let me take you, please, to bundle 1, page 34.
Okay. Page 34. Oh, my assistant has just gone out to the bundles. Let me check now. Okay, okay, I am on page 34.
All right.
Yes.
Bundle 134.
Yes.
And let's go to paragraph 2.1.2.
Yes.
The board had extensive deliberations on the matter. The following issues were highlighted in the deliberations. 1, acknowledgement that Mr. Gama was not challenging the finding of guilt against him, but the sanction imposed. Correct?
Yes.
Secondly, Mr. Gama's sanction of dismissal was too harsh, and the board will support a sanction of a final written warning valid for a period of 12 months. And from what you've told the chairperson...
6 months, Mr.
I beg your pardon, 6 months.
Yes.
For a period of 6 months, correct, Mr. Mkwanazi?
That is correct.
And from what you've told the chairperson, fundamentally what led the board to that conclusion is that you informed the board that you had a list of contraventions that were comparable to Mr. Gama's case, where people had not been dismissed, correct?
That is correct.
You've admitted that you perhaps shouldn't have created the impression that they were like for like, correct?
Yes, I agree. They were not like for like.
And then you go on to, or it goes on to record appreciation that Mr. Gama can still add value in the company. There was a minority not in support of the reversal of Mr. Gama's sanction.
Yes.
The company was mandated to finalize Mr. Gama's settlement agreement. And then the condonation process is a norm within Transnet. And to this effect, the chairman was requested to draft a memorandum to employees requesting that such conduct should cease.
That is correct.
What does that mean?
It means that in the system, there were too many condemnations and authorities floating around requesting condemnations. So what the company was trying to indicate is that it should cease, and only one person would have the authority to condone. And at the time, the idea was that it would have been Brian Molefe or the group CEO who deals with those condemnations. And yes, subsequently, if I recall, I had to deal with one condonation, the VAE condonation, if I can mention it. Yeah.
You've told the chairperson on Friday that you accept that condonation and disciplinary action are two different concepts, correct?
That is correct.
And then at paragraph 2.1.3, the board was of the view that under the circumstances, a final written warning would have been given.
Yes.
Would have been given. How would that have happened?
Chairman, I'm indicating that the board was of the view that under normal circumstances, a final written warning would have been given. But it's not a 100% correct statement, because the authority or authorizing individual would have taken a view based on each case, whether a written warning is taken or whether a disciplinary, that sentence is incomplete. But yeah, that's correct.
I mean, what you're saying here is effectively that if Mr. Gama had applied for condonation, then this is what would have happened.
It could have been denied as well, yes.
But that's what you were forecasting.
It's not captured, but it could have been denied.
You mean condonation could have been denied?
Denied, yes.
But whether granted, or not, or denied, that would not impact on whether he should be disciplined or not. That would be a separate issue.
No, Chairman, there are certain circumstances where condonation would have been denied, and therefore the next steps would have been disciplinary action needs to be taken. The question of whether you are condoned or not, and therefore you are absolved, never arose, except in situations where people did not even apply for condonation, which is a different matter.
Yes, so as you said previously, even if you are granted condonation, you can still be disciplined.
That is correct, Chairman.
Okay.
I just want to understand, Mr. Mkwanazi, if you don't mind. When it says the board was of the view that under normal circumstances, a final written warning would have been given. What do you mean by that? When would it have been given? How would it have been given?
Chairman, it depends on each individual case, because at times how these condemnations were coming, they were coming through what you'd call divisional internal audit committee meetings, where you then review offenses, procurement offenses, if I were to call them that. And then based on that divisional internal audit, an opinion is then formed that these offenses can apply for condonation, and these offenses need to be elevated to the authority FAP, and some of them maybe they need disciplinary action, because offenses are completely different. Take the issue of theft, for instance. I don't think any condonation would have been given for theft, and also assault and a few other things. Please no condonation would have been given. Yeah.
Sorry.
I was thinking of asking something, but I've decided to let you carry on.
Thank you, Chairperson. Mr. Mkwanazi, what you don't see here is any consideration or undertaking by the board of a review of Mr. Entrobus's decision. Correct?
Yeah.
I mean, no one says, well, this is what Entrobus found. We think it's wrong for these reasons. The board's just deciding this matter effectively afresh for itself, isn't it?
No, that is correct, Chair, although it had seen the Entrobus.
So is that what you were told to do then? And this is an important question. Is that what you were told to do by the minister? Just decide the matter afresh for yourself?
The request was a review. And upon that review, the procurement issues, there were some elements of unfairness on those two issues. But the third matter of him attacking Mr. Chris Wells and the board, it was oversight on the part of the board not to tackle that specific issue, because I do not think that that board would have taken a different decision to what Mr. Advocate Entrobus and maybe Mr. Todd had also recommended.
Yeah. But Mr. Mkwanazi, this minute does not reflect any application of the mind by the board to a review of Mr. Entrobus's decision. The board just decides afresh what it thinks should have happened, correct?
No, it does not refer to it, yes.
But why not? Unless you were hell-bent, you were hell-bent on having Mr. Gama reinstated, why didn't you undertake a proper, objective review?
Chairman, in hindsight, that should have been done, yes.
And isn't the position that actually the rulings of the chairperson of the disciplinary inquiry, because there were two, one on guilt, the other one on sanction, isn't the position that the mere instruction that you must review Mr. Gama's case had to start with a reading of those rulings and seeing whether they could be faulted, even before you can look at anything else? Wouldn't you agree that that would be the start? Yeah. Okay, all right. Mr. Maibek?
Thank you. Just one last question on the board meeting. Mr. Mkwanazi, Mr. Malungani, he says in his affidavit that you said that you had received legal advice to the effect that the sanction dismissal was too harsh. Did you say that?
I wouldn't call it legal advice that said it was too harsh. All I was indicating, I might have said it, was that if this thing is taken on the Transnet Bargaining Council process, there were chances that the Bargaining Council could come with a different option of how the matter could have been handled.
Yes, because...
yeah.
I mean, in truth, you hadn't received legal advice to the effect that the sanctions dismissal was too harsh. At best, you had received legal advice creating, as you've said many times, some doubt. Correct?
That is correct.
Perhaps this is an opportune time for me to ask you, you do know that this settlement cost the taxpayer, we'll come to the figures in a moment, I think about 17 million rand. Why do you settle a case just because there's some doubt?
I'm sorry, Mr.
Yeah.
Mr. Maibek. You probably mean the 17 million rand in terms of financial benefits to Mr. Gama.
Yes, I'll
Because,
come
of
to
course, the settlement agreement went far beyond that.
Yes,
in terms of legal costs and other things. You mean the financial benefits to Mr. Gama?
Yes, I think perhaps, Mr. Chairman, I'll come to that in a moment. But
Yes.
what was paid to Mr. Gama was approximately 13 million.
Okay.
And then there was about 4 million
Yeah.
in legal costs. You're absolutely right. It's the two together. But my
Yes.
figure of 17 million includes, not 17, includes the two.
Yes. No. I think I understand what you mean. I think your statement, I understood your statement to be saying you wanted to confirm that he knows that the settlement agreement cost Transnet 17 million rand.
Yes.
And I was simply saying you haven't counted the legal costs that they paid to Mr. Gamas, which would be far more.
Certainly.
You probably are just talking about what you have just said, yeah.
Yes.
Okay.
Well, Mr. Mkwanazi, we're going to come to the figures in a moment. But you know that this was a very expensive settlement, wasn't it?
I am aware, yes.
So that's really what I'm driving at. Why do you settle where the cost is enormous? Just because at absolute best for you, there's some doubt. That's all.
That is correct, Chair.
Why didn't you just let the process run? You could have saved this money, potentially. Why were you so
In
generous?
hindsight, advocate, yes.
Yes, but Mr. Mkwanazi, I'm going to press you on this because this is a very important issue. You've said time and time again to the chairperson, you settle because there's some doubt. Well, there's doubt in all litigation.
Yes.
I just cannot understand, even on your own version, what is the basis for entering into this very expensive settlement when all there is some doubt? Why give away the money?
Chairman, yes, there was that doubt, and on the procurement issues. But in hindsight, I don't have any doubt that on the third matter of attacking his executives, had the board applied its mind to that third matter, I doubt if that Mr. Gama would have been reinstated, or he would have said, no, there I would have supported the dismissal as well.
Well, Mr. Mybeck's question is, even with the two procurement issues,
Other matters.
yeah, why did you and the board decide to settle a matter just because there is some doubt that was created by a poor legal opinion, or weak, I think that's the term you used, a weak legal opinion that was not reasoned in any substantial way, when you had about 3 legal opinions saying you are on strong grounds against Mr. Gama in regard to this arbitration. So Mr. Mybeck's question is, help us understand why the board thought it was the right thing to settle in circumstances where the settlement was going to be so expensive, and yet the prospects of Transnet winning the case were so good, to your knowledge, in terms of the 3 legal opinions.
Chairman, I have indicated that, yes, there was this review by this, which came in the form of this weak legal opinion, which then created doubt, but unfortunately it was not thorough, because It was a general statement on doubt without looking at the three issues separately, because as I indicate, just on the third matter alone, which is not procurement related, a different decision would have been reached by that board if there was more emphasis on that third matter, which is not procurement related.
Mr. Mybeck?
Mr. Mkwanazi, I'm not sure.
I don't think you have got an answer.
I don't think I've got an answer.
But of course, if Mr. Mkwanazi doesn't have an answer, he doesn't have,
Fair
but
enough.
feel free to deal with it, with the issue the way you see. It is an important issue.
Mr. Mkwanazi, you accept that there's doubt and risk in all litigation.
Yes, I do accept that.
And that doesn't drive the responding party to settle all litigation, does it?
No, it doesn't, yeah.
So I'm just going to ask you once more. This settlement, we'll go into the figures in a moment, cost anywhere between 10 and 20 million. That's how much money you doled out to Mr. Gama. And you did that simply because there was some doubt that was not even articulated in the opinion. That's surely not rational.
Advocate, yes, at the time, that's the view we took as a board, and even that advice, as I've indicated, was not thorough, particularly on the issue of the third offense, and that's why had it been highlighted, particularly this third offense, I doubt if the board would have reached that decision. But on the other two matters, there could have been some doubt, definitely, yes.
Yes, but again, you're skirting around the question. If there was some doubt, there was also, we know, a prospect that you could win. Even you accepted that.
Advocate, yeah.
Correct. Well, then why didn't you allow the arbitration to run its course? Then we could have perhaps saved somewhere between 10 and 20 million. You knew there was a prospect of being able to do that. Why did you not allow the process to run its course?
Chairman, as you rightfully pointed out, Advocate, the issues of litigation can go either way. And at the time, if I recall, the board could have been worried about this thing taking abnormally too long. And therefore, the board could have felt that it needs to be resolved, but it's the wrong legal advice, which is the basis of saying, yes, maybe on the first two issues, there could have been some doubt. But on the third issue, no, the board didn't get good advice. And also, yeah, basically the board would have sustained the decision of the disciplinary committee.
What would you say if somebody said this decision by the board is indefensible?
Chairman, I would tend to agree with you because it's indefensible because the board did not have the facts of the last matter in terms of that particular offense. It never surfaced on documentation that this third offense was almost a dismissible offense under any circumstance, Chairman. I agree with that.
Mr. Mybeck?
Thank you. Mr. Mkwanazi, what I now want to do is deal with some of the relevant concepts, condonation, whether or not it was applicable, and the like. Can I ask you please to turn to Mr. Todd's further affidavit? That's in bundle 3 at page 1. Bundle 3, and it starts at page 156.
8156. Okay, I've got it in front of me.
So what Mr. Todd does in this affidavit is, if you have a look at paragraph 6, he deals with your reasoning and the decision to reinstate in the light of the issue of condonation. And then at paragraph 7 he says, this explanation is, in my respectful submission, not rational, does not ring true on its own terms. The explanation cannot be correct for the following reasons. And then he summarizes 4 points that he then expands upon. First, condonation was a procurement process entirely distinct from decision-making about the consequences that should follow from employee misconduct. Second, not one of the 3 instances of misconduct to which Mr. Gama ultimately admitted and for which he was dismissed was capable of or suitable for condonation as an application of the procurement policy. Third, such contentions as Mr. Gama sought to make during the disciplinary process concerning consistency of treatment were fully, carefully and fairly considered by the disciplinary chairperson, as appears from his lengthy findings. And then fourth, as far as I'm aware, there was no report or evidence before the board when the decision was taken to reinstate Mr. Gama that showed a track record of condonation being granted, etc. And I want to now go through each of those points. If I can take you, please, to the heading, Condonation, a procurement process distinct from decisions on employee conduct. Mr. Todd says, to the best of my knowledge, condonation within the Transnet procurement environment had nothing to do with condoning acts of misconduct by employees. And I understand you've accepted that.
Yes, Advocate, I agree with that statement.
Condonation was a procurement procedure under which a person or body with authority to incur expenditure was permitted to, and I was quoting from your manual, condone non-compliance with the laid down policy and procedures and directives provided such non-compliance is submitted via the relevant line manager of the employee in the particular division. You would agree with that?
I agree with that, Advocate.
I refer in this regard to the opening paragraph of the Transnet internal memorandum, and we're going to come to that in a moment. Paragraph 10, in this way, usually minor deviations, again the language of the memo, from required procurement policies could be condoned after careful consideration by the authorized person or body, so that if expenditure was approved or had been incurred in these circumstances, it would not constitute unauthorized or irregular expenditure for the purposes of the PFMA. You agree with that?
I agree with you, Chairman.
Then at 11, the distinction between condonation as a procurement procedure and disciplinary processes to deal with employee misconduct is a logical distinction which is apparent from Transnet policy directives at the time, including Annexure A. You've already accepted that, correct?
Yeah, that I agree, Advocate.
That memorandum deals with the authority of what is referred to as the Divisional Acquisition Council, the procurement body within a Transnet division, to condone non-compliance with prescribed procurement policies and procedures. You accept that?
I agree.
As the memorandum makes clear, condonations, quote, are not there for the asking, correct?
I agree with you.
Little b, as a general rule, condonation should be given for relatively minor transgressions of procurement rules and procedures, and that material non-compliance will usually not be condoned because these have this is a quote, PFMA implications which could result in civil, criminal or disciplinary steps being taken. You would agree with that?
I agree with that.
Then over the page, a condonation submission was required to state whether disciplinary steps have been taken because of non-compliance, correct?
Yes.
And D, even where matters have been submitted for condonation, where certain individuals are found to be guilty of transgressions, disciplinary action should be considered. You would confirm that?
I agree. Yes.
In summary, said Mr. Todd, the two processes, one, condoning minor non-compliance with rules and procedures, and two, responding to employee misconduct, were at all times, both as a matter of logic and as a matter of policy, entirely distinct. Correct?
They are distinct, yes.
And then you will see, I'll come back to the affidavit or the body of it in a moment, but could you please go to page 168.
168.
There is Annexure A, and it's the PPM Directive of March 2010 dealing with condonation. And really, what Mr. Todd did is he analysed and quoted in his affidavit from this Annexure A. And you've agreed with his analysis, correct?
Yes, I do agree.
So then, if you go back, please, to page 160.
Maybe before that, Mr. Maibek, Mr. Mkwanazi, while on that page 168, won't you, or no,
yes.
at page 168, you will see at the bottom of that page that the memo says the DAC's role. The discretion which the DAC has to grant condonations must be carefully exercised, taking into account all relevant factors. These include the following. 1, the extent and cause of the non-compliance. 2, the seriousness of the non-compliance. 3, the reasonableness of the explanation for the non-compliance. 4, the effect of the non-compliance on the fairness of the procurement process. 5, whether the matter would in all likelihood have been approved had the proper processes been followed. 6, whether the DAC was approached for condonation as soon as possible, in brackets at the next DAC meeting, close brackets, after business became aware of the non-compliance. You see that seems to be,
yeah.
Those seem to be the factors which the memorandum says should be taken into account when considering whether or not to grant condonation. You accept that?
I agree, Chairman.
And on the next page, page 169, you will see a heading that says information to be contained in a condonation submission. Can you see that heading?
I can see that heading.
And then it says, at the very least, a submission to obtain condonation should contain the following information. 1, when did the business first become aware of the non-compliance? 2, the nature of the non-compliance, including the provision of the PPM, in brackets, or construction procurement manual, close brackets, that was not followed. 3, a full explanation for the non-compliance, i.e., why was the process not followed? 4, what steps will be taken to ensure that the non-compliance will not occur again? 5, has any person been reprimanded or has disciplinary action been instituted against any person because of the non-compliance, in brackets, including details thereof. And if you go a little down, you see a paragraph that says, matters submitted for condonation must be regarded in a serious light, and where certain individuals are found to be guilty of transgressions, disciplinary action should be considered. You see that?
Yeah.
Now, in relation to the 30 or whatever the number is of condonations that you said had been granted in terms of the list that you had before you in a spreadsheet, you would not have had all of this information to see in each case in order to be able to compare with Mr. Gama's case, isn't it?
I would not have had that.
You would not have had all of this information in regard to each one of them.
I would not have it.
Yes.
Yes.
Okay, Mr. Mybeck.
Mr. Chairman, I see that it's 11:15. Is this a convenient time to take the tea adjournment?
Let's take the tea adjournment and we'll resume at 11:30. We adjourn.
Mr. Mkwanazi? Mr. Mkwanazi? Mr. Mkwanazi? Mr. Mkwanazi?
Yes,
We are about to start.
I'm there.
We are about to start.
Okay.
Okay, thank you.
Okay. Okay.
Thank you. You may be seated, Mr. Mkwanazi. Let's
Thank you,
continue.
Chairman.
Let's continue. Your mic, Mr. Mybeck.
Thank you. Mr. Mkwanazi, Mr. Chairman, I've been asked to face this way.
Or are those the TV people?
Yes, so I'm sorry.
They want to see your face better. Okay, all right.
Thank you.
Does that mess up your plan with your table there?
I'll sort it out
Yeah.
at lunchtime, but I'm sure I can limp on,
Yeah.
Mr. Chairperson. Thank you. Mr. Mkwanazi, can I please then take you to the next topic that is dealt with by Mr. Todd? And this is at page 160 of Bundle 3. He says, no condemnation would or could have been applicable to Gama's misconduct. Paragraph 13, quite apart from the logical distinction referred to above, not one of the three instances of misconduct for each of which the sanction of dismissal was imposed on Mr. Gama would have been suitable for or capable of condemnation in the sense contemplated in Transnet's procurement policy. So A, he deals with the 50 like new locomotives. He says, the misconduct in relation to the 50 like new locomotives arose from Mr. Gama's conclusion of a major contract that had been authorized by the board, but with Mr. Gama failing to comply with the single important condition prescribed by the board, which was that local, in brackets South African, close brackets, work performed on refurbished locomotives should be done by Transnet itself and not by an external partner. Mr. Gama's conduct in concluding a contract that directly contradicted this condition was not a procurement irregularity that could be condoned. And more importantly, it was not in fact condoned by the board. On the contrary, the board required the contract to be cancelled, with Transnet incurring various significant costs as a result. No question arose of irregular expenditure that could be condoned on application by Mr. Gama. Mr. Gama did not in fact apply for condonation, and this would in any event not have mitigated or detracted from the serious concerns about his conduct, which the disciplinary chairperson found to have justified his dismissal. So, the long and the short of what Mr. Todd is saying is that Mr. Gama could never have got condonation because this irregularity wasn't condoned. In fact, to the contrary, what the board required was the cancellation of the contract, resulting in Transnet incurring various significant costs. Do you wish to comment on this?
I understand fully the argument of Mr. Todd. Having said that, though, and as he rightfully points out in terms of that board decision, I'm also now not sure if this matter is actually, meaning in retrospect, a condonable matter. I'm not sure.
Yeah, well, I think that's a concession fairly made.
I'm not sure.
Well, let me then deal
Well,
with...
Mr. Todd says, he clearly says it wasn't a matter that would fall under condonation, that would attract condonation. As I understand his argument, maybe not just based here, but maybe based elsewhere in his affidavits as well. This was a case where the board had given, in effect, an instruction, and that instruction was effectively defied by Mr. Gama. Condonation has got nothing to do with that, does it?
It does not.
Yes.
I agree, Chairman.
Yes. Okay, all right.
And then just to add to that, Mr. Mkwanazi, so that deals with the misconduct side of it. But on the condonation side of it, Mr. Todd says, well, condonation could never have been granted because this actually wasn't condoned. What happened is that the contract was cancelled by Transnet and it incurred various significant costs. Correct?
That is correct.
All right. Let's then go to page 161, paragraph
Yes.
B. We're now dealing with GNS. The procurement irregularities in relation to the appointment of GNS were completely unsuitable for condonation for various reasons. First, the procurement process was so seriously flawed that no rational person could have attempted to use the condonation procedure to seek to regularize it. I refer to the multiple and serious respects in which the process was found to be defective by the chairperson of the disciplinary proceedings brought against Messrs. Kanya and Sanamela, as appears from the copy of the findings. Now, I've taken you or mentioned those before. Those are the findings, marked B, the findings of Nazir Kasim SC. You would have read them, no doubt?
I know Percy's issue, yes.
Yes. And you'll see that that finding tabulates an absolute litany of irregularities caused and affected by these two employees who were then dismissed, correct?
Yes.
Mr. Todd goes on to say, second, and perhaps more importantly of relevance to Mr. Gama's position, Mr. Gama himself had described it as an irregular process which had been materially misrepresented to him by the official who had procured his signature on the crucial procurement document. Mr. Gama described the process as, quote, fishy and a scam, and stated that he would not have approved it if he had known the true facts at the time. You accept that?
Yes.
Mr. Todd goes on to say, I attach, marked C, a transcript of part of the disciplinary proceedings that took place on 10 February 2010. As is apparent from the transcript, Mr. Gama stated that when he had later seen the confinement document after an investigation into the matter, he had realized that there were, quote, quite a few gaps and loopholes, unquote. He had begun to smell, quote, something fishy, unquote. Stated that if he had known that it was a confinement, he would probably not have approved it. Confirmed that it had been improper to stop an existing tender process when GNS came into the picture. Confirmed that what the relevant official had done by representing to him that a tender process had been followed, quote, was a complete fraud. And stated that, quote, once you get all the documentation, it becomes clearer what was happening, unquote. And stated that at the time when he received all the relevant documents in June, quote, it became clearer to me in terms of what this scam was about. It makes no sense, says Mr. Todd, when this was Mr. Gama's own stance on the matter, to suggest that the procurement condonation procedure would have been appropriate in these circumstances. Would you agree with that?
No, I agree with that. Yeah.
So we're two down. And then what Mr. Todd says in C is the third charge of misconduct, as you've accepted, for which the sanction dismissal was also imposed on Mr. Gama, had nothing to do with procurement at all. So on this, affidavit and these paragraphs 13 through paragraph 13A, B, and C, you accept, Mr. Mkwanazi, I take it that there was simply no basis to come to the finding that the committee did?
The committee, yes, applied its mind and looked at the two issues as indicated. And there was nothing wrong with the finding of that particular committee, meaning the Antrobus processes. There was nothing wrong with them, yes.
Yeah, sorry, what I meant to say is that one simply can't justify the conclusion and decision of the board, can you, to reinstate Mr. Gama on the basis of these paragraphs? It's just impossible.
Chairman, based on Mr. Todd's submission, which is what we've got now, there could have been a different interpretation of whether condonation could have or could not have been granted. But Mr. Todd's analysis indicates that no condonation would have been granted under these circumstances.
Yes, and you accept that?
Based on his submission, I accept that, but the thing was not tested. When I say not tested at the time, I'm not sure if did Mr. Gama discuss some form of condonation. I'm not Mr. Gama's representative, because based on a different type of, the first one, by the way, of the 50 like new, was a strange one. He basically didn't follow a board process. But then the question then becomes, did he do a confinement in terms of discussions with the authority that had approved this? That's on the first one. The same on the second one. Did he do a confinement on the GNS? I don't know. But based on what he then said as well, that this thing was wrong, etc., etc. But he did not test condonation on the two issues. The last one of misconduct, the dismissal was a fair sanction.
Yes, but let me put it this way, Mr. Mkwanazi. Let's just take the 50 like new. You fairly conceded to the chairperson that, well, we know that condonation would never have been granted. That we know. Because the contract wasn't condoned, wasn't regularized, it was cancelled. But leaving condonation aside, you've conceded to a question by the chairperson that it didn't detract from his misconduct, that what had happened here is that Mr. Gama had defied an instruction of the board, correct?
No, I agree with you.
An important instruction. And his misconduct is serious, isn't it?
It is.
Right, so that's 50 like new. Now GNS, just so that you follow, Mr. Todd accepted the proposition that I put to him, that Mr. Gama's case in relation to GNS is that he signed what was a confinement blind without having any regard to anything and allowed a fraud to be perpetrated on Transnet. That's his own case. Now, you're not going to condone that, are you?
No, you can't condone that either.
And you would accept,
yeah.
Yes, sorry, I don't want to interrupt.
Please continue. No, continue.
And you would accept that for a CEO of a major division of Transnet to conduct himself in that way is quite appalling, isn't it? To blindly sign a document that allows a fraud to be perpetrated on the company. Correct?
No, correct.
You're not going to condone that, and you accept that that's serious misconduct. Correct?
It is. Now, in hindsight, if I was the authority to look at condonment and things, I would not have condoned that GNS thing as well. Also, based on his own admission when this matter was brought into the disciplinary inquiry.
Because we know that you treated him on the basis as if condonation had been granted.
That is correct, Chairman, yes,
But-
Advocate.
Mr. Mkwanazi, you say in hindsight, and you make fair concessions here today,
Yes.
but why in hindsight? Because what Mr. Todd is saying here is really no different to what Mr. Entrobus said in his findings. The reality is that you didn't come to the decision that you say you would have come to today simply because you didn't apply your mind. You had an ulterior purpose, Mr. Mkwanazi. Surely you must concede that. Surely.
Not really, because still at the time when even I looked at my own submissions to this process, I did indicate that there was some serious oversight on the type of the advice and the recommendation to the board, that the last matter, which I viewed almost as a serious misconduct of attacking his colleagues, is not a procurement matter and is not condonable, that matter. That matter, definitely, he should have been dismissed. Now, at the time of writing my first affidavit, I interpreted the first two matters as procurement matters. But now, as we go through this process, I can see that he considered himself as well that they were not necessarily hardcore procurement issues, which is why even the 50 like new, the board had to cancel that contract with whoever supplier. And also he himself as well admitted that on this GNS contract, according to what you're indicating, that there was something fishy about the contract. But myself, at the time of doing my affidavit, I just viewed these two items as procurement, the first two items, as procurement irregularities or as issues relating to procurement, and not necessarily even issues relating to misconduct, as is indicated by the 50 like new, in not following a board instruction. And also even the second one of him signing that GNS contract, where from what I pick up, I'm not sure if it was a confinement or what, but there's no clear submission that this would have been condonable as a confinement. I don't know, yeah.
Well, you do recall, Mr. Mkwanazi, don't you, that when you did your first affidavit,
Yes.
the commission had taken trouble to make available to you the two rulings of the chairperson of the disciplinary inquiry, as well as Mr. Todd's affidavit, as well as Mr. Todd's report that was before the board, to make sure you could refresh your memory. You remember that?
Yes, I do.
Yes, okay, all right. Mr. Maybeck.
And then, in conclusion, Mr. Mkwanazi, what Mr. Todd says at paragraph 14 of page 162 is to state in these circumstances that the board, and this is what you had said, quote, had to somehow try and deal with the Gama matter on the assumption that he had been granted condonation, had it been offered, and therefore had to try and put him in a position that he could have been in had condonation been offered, simply cannot be correct. And I think you concede that, correct?
Yeah, I concede that, yes.
But Mr. Mkwanazi, I'm going to press you on why did you not come to that conclusion at the time? It seems to me you couldn't have read Mr. Entrobus's finding. It seems to me that you couldn't possibly have read Mr. Todd's report.
Or if you did read them, you may have decided to disregard them. Either you read them, or either you didn't read them, or if you read them, for whatever reason, you may have decided to ignore them. Okay.
Chairman, I did read Mr. Todd's submission of the 2nd of February, 2010, if I do recall.
Yes.
But I did read Mr. Todd's submission, but at the time, that's why even my analysis of what I call the similar procurement issues. They are not identical to this.
Yes.
The other similar procurement issues could be minor, but again, somebody must look into them compared to what is sitting in front of us.
Do you have a clear recollection that you had read the two rulings of the disciplinary chairperson, the chairperson of the hearing?
Chair, I would have read these, but the one I do recall
is Mr. Todd's
a little
one.
bit more is the Mr. Todd one of which was submitted to the board of the 2nd of February or around that time. I do recall that one.
Well, you see, those two rulings are quite comprehensive. It seems to me that anyone who has read them will not forget that they read them. They are quite comprehensive. You have to put aside time to really read them.
Not true, I do recall.
Do you recall that you did read them?
Chairman, not as comprehensively as Mr. Todd's submission of the 2nd of February.
Okay, all right. Mr. Maybeck?
Yes, thank you. And then Mr. Todd goes on at page 163 to deal with the contention that Gama's own contentions on consistency were fully and fairly considered in the disciplinary process. I mean, did you notice that when you read Mr. Todd's report, that the concerns that you say you had about condonation and inconsistency, those were considered by the chairperson? Did you see that?
Yes, they were considered.
So why did you not then simply leave things be? He had considered it. He had applied his mind to it. He concluded that there was no merit in it. Why did you just override that?
Chairman, I did need almost what you can call a separate and different view of these issues, particularly in view of the public protector matter, et cetera, which would have come much later compared to all these other processes that had been going on. So in trying to look at the Gama matter, there were some, I now view them almost as not identical. There were some areas where Mr. Gama or whoever would have thought that the processes that dealt with him were unfair, but looking at the issues themselves, they were not that unfair. But there were some procurement processes which were not handled the same way as Mr. Gama's matter was handled.
Yes, but Mr. Mkwanazi, I think you're missing my point. Mr. Antrobus had applied himself to that contention that was made by Mr. Gama, and he had rejected it.
He's a senior counsel. He's a labor lawyer from what I've read. He had been, it was acceptable to all sides to run the disciplinary hearing. When you look at his rulings, you can tell that he took time to deal with issues that had been raised very, very thoroughly. So, Mr. Maybeck's question is, why did you and your board think that you could just override his decision when these very issues had been raised with him and he had considered them thoroughly?
I wouldn't call it override, except that we did look for another opinion, particularly in view of the Transnet Bargaining Council process. And this other opinion looked at this issue and created some doubt that we could or could not sustain our case at the Transnet Bargaining Council.
But Mr. Maybeck has at some stage effectively said to you, you couldn't settle because there was some doubt. Because in litigation, in arbitration, there is always some doubt. There is no 100% guarantee that you are going to win. Even when you have a strong case, there is always some doubt. Therefore, when you were told, when you were given an opinion that in your view created some doubt, that should have been neither here nor there until the doubt that was created said to you, we don't have reasonable prospects of success. As long as it was just some doubt, that's like any other case. That shouldn't have weighed with you at all, because there is always doubt in arbitrations, there is always doubt in litigation. So what he put to you is, that should not have swayed your view of what you should do. What do you say?
In hindsight, Chairman, I would agree that that doubt should have been examined further to look at the actual risks, and which might have come back and said that risk is actually no risk. I agree with your input, Chairman.
Mr. Maybeck.
Yes, thank you. Mr. Mkwanazi, you see how you fall back now on the Denise Rates advice. But the Denise Rates advice doesn't say anything about condonation or inconsistency. Nothing.
No. Yes.
Well, then explain
I
to
agree,
me.
Advocate.
How did you do this?
Advocate, I did indicate that the Denise Rates advice was frankly very weak, because it did not focus on the specifics like Mr. Todd did. The Denise Rates was a weak legal advice. And as I indicated, even though there was these three issues, the last issue of misconduct by Mr. Gama in terms of attacking his executives is almost non-condonable, if I can use the word. But because of the interpretation at the time of thinking that these other two issues are actually procurement issues, and therefore when the statements were made on unfairness, either to the public protector or to whoever, and things were looked at, we felt that there could be a slight risk in those first two. But now, in hindsight, looking at the submission by Mr. Todd again, those were not necessarily procurement irregularities. They were almost misconduct of not following board resolutions. That's the first one, the 50 like new. And the second one as well, the GNS was a different type of misconduct. Looking at it now, where the individual concerned didn't apply his mind thoroughly before signing whatever documents that he might have signed. Yes.
You used the words a slight risk. Are we down to that now? You settled because there was a slight risk. That's what you said, right?
Yes, I might have said that. Yes, I agree.
So this cost the taxpayer somewhere between 10 and 20 million because you and your board said, well, there's a slight risk, so let's just pay him that. Correct?
Let us settle, yes. Paying the quantum you mentioned, at the time, I'm not fully aware of the exact quantum, but it would have come to that based on the detail then that had to be entered into to quantify whatever settlement amount was involved.
We're gonna come to that. Just to end off on this topic, about the fact that the chairperson had dealt with this. Can I ask you please to go to page 86 of bundle 3?
Page 86, okay. I've got page 86. Yes.
So I'd like to take you to the middle paragraph. This is a finding by Antrobus SC. It was contended that the first and second charges are an entirely new formulation at Transnet. This is Mr. Gama's contention. As it has never occurred in the history of that company that a CEO or senior executive for that matter has been held to have committed misconduct for activities and practices that are usually automatically condoned and accepted by various mechanisms and committees within Transnet. So that's what Mr. Gama said, and that's also what you found. And the chairperson goes on to say, apart from the fact that there's no evidence to this effect, it seems to me that if the conduct in question amounts to misconduct, and then it is misconduct quite regardless of what mechanisms and committees within Transnet may have to say about that. I understand you to have accepted that now.
No, I do accept
that condonation and misconduct are different things.
Yeah.
And then he goes on to say, if the submission is an attempt to make out a case of inconsistency, then it's necessary to say no more. Then I have already concluded in the previous findings that there's no merit in the case of alleged inconsistency. But you just came to a different conclusion, right?
Yes.
So let's go perhaps closer even to the mark, to page 164, forward in this file.
164.
164.
Okay, I'm there.
So I want to take you to the quotation at the foot of the page. It is further contended that I should take into account the fact that there were in the same financial year in which Mr. Gama committed his acts of misconduct some 42 incidents and transgressions of corporate non-compliance or irregularities, in respect of which nothing was done, in brackets, presumably by way of taking disciplinary action. So Mr. Gama had a list of 42. You had a list of 30, right?
Yes.
So he made this case, Mr. Mkwanazi, you laugh, but he made the case that you made at the board at the disciplinary hearing. And the chairperson says, it is not clear to me to precisely what evidence reference was being made in this regard. However, insofar as it refers to the report of the tender process audit, this is no more than a recasting of the alleged inconsistency issue, which has already been rejected in the previous finding. In any event, even if there is other evidence to which reference is being made in this regard, it was certainly not established that the other incidents were of a similar factual nature or similarly committed by a senior executive. And you've conceded that too, that you had your list, but you couldn't establish like for like similarity, could you?
That is correct, Advocate.
So here's the irony. The very basis upon which the board makes its decision is rejected by the chairperson, and you accept that it was correctly rejected now in your evidence. Correct?
Yes, I do.
Well, Mr. Mkwanazi, I'm going to put you again. Surely the only rational explanation for the manner in which you and your board conducted yourself is that you had an ulterior motive. You were carrying out the instruction of the minister to have Mr. Gama reinstated. Isn't that true?
The instruction was a review, and somehow at the time, also based on some information which I had, this 30 or whatever list of people which I had seen in January of 2011. And although, as I indicated, they are not like for like to even the first two matters, it did create some doubts on
I'm going to stop you there, Mr. Mkwanazi. I'm sorry, I'm going to stop you there. Go back to Mr. Maibek's question and just answer that question. Mr. Maibek, do you want to repeat the question?
Yes, essentially what I'm putting to you, Mr. Mkwanazi, is the facts show that you and your board acted so irrationally that the only reasonable explanation is that you must have been carrying out an instruction from the minister to reinstate Mr. Gama.
Not that it was not an instruction to reinstate. It was an instruction to review. Yes, we do look into that, but based on this latest information that one keeps getting, even that review would have been fault or a false review, in that on some of the matters that Mr. Gama was charged for, he was dismissed, and even that board, had it had that information, would have confirmed the dismissal.
Well, you have an issue that had been dealt with by the chairperson of the disciplinary inquiry, which Mr. Mybeck referred you to at page 164. So it's quite clear the chairperson dealt with this issue of inconsistency. He says a reference was made to 42 incidents or transactions. So Mr. Gama had the opportunity to present his case that he had been treated inconsistently, to present it before an independent forum, chaired by a senior member of the bar, paid for by Transnet. He was allowed to use his own team of lawyers of his choice, so that they could present the best case that they could for him. He fails. And then you are instructed to review his case. You come back, you review his case. You don't say to the minister, but there is a forum where Mr. Gama got a chance to present his case. We should not interfere. We as the board will accept the outcome, whatever it is. If that forum says we must reinstate him, we'll reinstate him. If it dismisses his claim, that will be it. We should not interfere, Minister. Why didn't you say that?
At the time, I did not say that to the minister, yes.
But do you agree or do you not agree that that should have been your attitude and that should have been your board's attitude?
At the time, based on whatever review that could have been done, that review would have highlighted that the Transnet Bargaining Council could have dealt with this issue in a particular way, and even confirmed some of the sanctions that were applied by the antitrust process.
So do you agree or do you not agree that at the time of the settlement, the correct approach on the part of your board should have been, Minister, there is an independent forum, the Bargaining Council, which assists with this matter. It has been dealt with by another independent forum chaired by an independent chairperson. Mr. Gama presented his case. He failed. We didn't interfere with the chairperson of that forum. He will go to another forum now. It's independent. We will not interfere. We will abide the decision of that outcome. That do you not agree that that should have been your approach at least?
Chairman, that could have been the approach. I do agree with you. But for some reason and in view of an element of certain allegations in the public protector letter, then that review made sense. But even though that review made sense, the legal advice we got was extremely weak. And also the so-called procurement irregularities that were sort of alleged to have happened. In Mr. Gama's case, the two key matters, the 50 like new, frankly, it's not a procurement matter anymore, rather than be a not following board instruction. It's different to procurement. And even the GNS matter, from what I pick up here, he himself did agree that that procurement process was faulty, et cetera, et cetera. Now, at the time, as looking at that review, we even the advisory court did not fundamentally go to the source of where this alleged procurement is coming from, because if you go to the source of where this alleged procurement is coming from, the complexion of the matter differs completely. Because yes, there are two procurement issues, and then there's an issue of what I would call misconduct. Yeah.
But of course, you will concede, won't you, that you shouldn't put yourself and the board and your board, you shouldn't put the matter as if you and your board were the victim of some poor legal advice, because you did have sound and strong legal advice at your disposal that had been given by Mr. Todd, and you chose to follow what you call the poor legal advice. It was your choice, it was your board's choice. It's not as if there was no choice to follow sound legal advice. You agree?
I agree with you, Chairman.
Yes. Mr. Mybeck?
Yes, thank you. Mr. Mkwanazi, you repeatedly say that before the decision was taken, there was a review. There was no review, Mr. Mkwanazi. There was no review at all. To undertake a review, you first have to understand and appreciate what Mr. Antrobus did. And then you've got to understand and appreciate why what he did was wrong. You didn't do any of that. There was no review. Correct. So insofar, and I put this to you already, insofar as...
Just let's get that. What's the answer to that, Mr. Mkwanazi?
The advocate is questioning is correct, because when you do when you ask somebody to do a review, be it that legal firm, whatever it is, they must go back to the actual outcomes and then do a proper review. I don't think they did. They just came with a very weak document indicating doubt on the processes going forward. Yeah.
But he's talking about you and your board. He says it's not correct that you and your board did a review, because when you do a review in a matter like this, you would have had to go to Mr. Antrobus' rulings and look at them carefully, which does not appear to have been done.
I concede that my board did not do a thorough review. It just went for a different legal opinion on the fairness of the sanction, et cetera, on the three offenses. And yet, in hindsight, looking at even those three offenses now, the legal review we got was exceptionally weak, yeah, or opinion was exceptionally weak.
Mr. Mybeck.
Yes, so I think I've already put to you that insofar as the minister's instruction was that you should undertake a review, you didn't do that. Correct?
It's not a thorough review. I concede to that as we're talking now.
But insofar as the minister's instruction was that you should simply reinstate the man, you certainly fulfilled that instruction.
It was not the instruction to reinstate, it was an instruction to review the dismissal sanction on the man.
I just want then to end off this by referring you to, I think, 3 parts of Mr. Todd's report again. Under the heading, dealing with sanction.
I'm sorry, Mr. Maibek, just want to follow up on your last question.
Yes.
Mr. Mkwanazi, I'm sorry, I'm just interrupting Mr. Maibek. Understanding that Mr. Gigaba had, according to your evidence, instructed you to conduct a review of the Gamma matter, and understanding that he had said that on your evidence there was unfairness, understanding that he had given at least a basis for his thinking that there was unfairness, namely, as I understand your evidence, some white executives were treated less, more leniently or less harshly than black executives. And he had also mentioned the issue of condonation. And are you able to say what outcome of the review would have addressed his concerns, on your understanding?
Chairman, my understanding, that outcome would have addressed a few concerns that he might have had. That review would have looked at whether the Gamma matter was fair, and they were all aware that the process was very fair. And also then that review would have looked into what similar offenses
I'm sorry,
committed.
Mr. Mkwanazi. I'm sorry, Mr. Mkwanazi.
Yes.
I might not have articulated my question as clearly as I should have. The question is not about features of the review process. Okay?
Okay.
It's not about that. It's about what outcome of that review process would have addressed his concerns that there had been unfairness on your understanding.
Now, my interpretation of whatever outcome, it could have indicated that, yes, there was unfairness in how the Gamma matter was handled. But that outcome did not even go to the detail of some of the so-called perceived unfairness around how the Gamma matter was dealt with.
Mr. Maibek?
Yes, thank you. Mr. Mkwanazi, let me just end off by referring you to 3 passages. You go to page 81 of bundle 3.
Page 81. Yes, I'm there.
So this is where Mr. Todd deals with how Mr. Antrobus dealt with sanction. And you see at the foot of the page, he deals with charge 1.
Yes.
There's there the negligence on Gama's part in signing the GNS confinement document is nevertheless particularly inexcusable. You see that?
I see that.
And then if you go over the page to page 82 at the bottom, Transnet is placed in a position where
Yes.
it can really not be confident, once negligence of this nature has occurred, that Mr. Gama will in future be sufficiently careful to ensure that he knows whether what he is signing is a confinement or an open tender contract. Gama is the CEO of the largest division in Transnet, And in fairness, the company cannot be expected to continue to employ him in this role while the company lives with the doubt as to whether or not he will again in future make an error of this nature. It's compelling, isn't it?
It is compelling, yes.
I mean, you can't have a CEO who signs a document blind and allows a fraud to be perpetrated on the company, can you?
You cannot, yes.
And then charge 2, if you go to page 84,
Yes.
so now we're dealing with the 50 like new. The second paragraph at 84, one must have regard to the fact that the board needs to be able to be confident that when it delegates authority to a divisional CEO subject to a particular condition, that he will take specific and reliable steps to ensure that that condition is complied with. In fairness to the Transnet board, it would be a big ask for the board to be required to continue entrusting Gama with large management projects when he had exhibited negligent failure of this nature and with these consequences. Compelling, isn't it?
It is compelling, yes.
And then, in dealing with the unwarranted criticism of Transnet and its executives, at the top of page 85, Gama's public statements demonstrate, and this stuff you all agree with at least, demonstrate without doubt that there's been a total breakdown in trust and confidence between the parties. You accept that? Mr.
I do
Mkwanazi?
accept that.
Yeah. And then, the damning finding, which I've already taken you to earlier in my questioning, at page 88, just above paragraph 60, halfway through that quote,
Yes.
this is now dealing with charge 4, this charge goes to the heart of Transnet's loss of faith in Gama, and there can be no doubt that dismissal is the only appropriate penalty for Gama's conduct under this 4th charge, and you've accepted that on many occasions.
I agree that,
Right.
Chairman.
Let me then move to another issue, and that is the terms of the settlement agreement itself.
Before that, Mr. Maibek, we have the situation, Mr. Mkwanazi, that although you make the concessions that you have made, and I think they are properly made, about the matters that Mr. Maibek has just raised with you with regard to the findings of the chairperson of the disciplinary inquiry, you and your board, in effect, said, we want a CEO of a large division of Transnet who signs documents without reading them, and thus places Transnet in a serious financial risk. That's the CEO we want. We want him to be reinstated. Do you agree that that's the effect of your decision and your board?
Chairman, I agree with your comments, yes.
Yes. And you said, in effect, by your decision, this CEO defied an instruction of the previous board, but we want him back. We want him back. And of course, the other charge has been dealt with. A CEO who publicly criticizes other executives as well as the board, we want him back. And we'll pay him full back pay. It's inexplicable, isn't it? You would accept that.
Chairman, in hindsight, as you articulate these, it is inexplicable, particularly, as I had indicated earlier on, the last charge
Yes.
of fighting your CEO and your board.
And your
It
board.
is totally unacceptable.
Yes, yes. Mr. Maibek?
Thank you. Mr. Mkwanazi, please could you turn to file 1
File 1.
and
I'm not sure. Okay, let me put
That's
this one away.
bundle 1.
bundle 1.
What page?
Page 36, the settlement agreement.
Page 36.
So as you know, that settlement agreement is found in many places in the documents, but it first came to light or was officially provided by the company secretary, and that you find at page 36.
Yes.
I'm sorry, you said we must go to the settlement agreement at page 36. Mr. Maybeck?
Yes, Mr. Chairperson.
Okay, all right.
That is the one that you signed on the 22nd of February, correct? At page 41.
Page 41, let me go back there. Okay. Yes, on the 23rd of February, that is correct.
Now,
Well, you signed on the 22nd of February, Mr. Gama signed on the 23rd.
22nd of February.
Yeah.
22nd, I think so, 22nd, yeah. I can't see very well. Yeah, 22nd of February.
and Mr. Gardner signed it the next day, it appears.
It appears that, yes.
So I'm going to come to the terms of this in more detail. But Mr. Mkwanazi, what I've always been intrigued to find out from you is, will you accept that Mr. Gama, during these negotiations, took you to the cleaners? That you, on behalf of Transnet, completely capitulated during the course of the negotiations? You couldn't have done a worse deal for Transnet. Correct?
In hindsight, Mr. Maybeck, Advocate Maybeck, just based on that last item we've been discussing of misconduct to his colleagues, the CEO and the board, there would have been no such settlement agreement, because I would have supported the view of a dismissal. But on what I can then define as a preconceived interpretation of procurement irregularities on those two other matters, which now in hindsight, some of them are not even procurement irregularities. If you look at the 50 like new, he basically didn't follow a board instruction. Then on the GNS contract, there's an element of a procurement irregularity because he confined something that he had not applied his mind to. Yes, but based on that last matter of attacking his colleagues, this thing would not have been even negotiated, and I would not have accepted such a settlement agreement.
So I think you might misunderstand my question. I'm dealing with the very generous terms of the settlement agreement.
Oh, yes, yes.
Where they represent
Please
a complete capitulation and a bounty of benefits for Mr. Gama. So let me start by asking you the question again. Do you accept that during the negotiations, and I'm talking about the terms and conditions that were agreed upon, the payments that you undertook to make him, the cost contribution that you undertook to make, you completely capitulated during the negotiations, correct?
A complete capitulation is a strong word, but yes, I would accept it.
Well,
Mr. Mkwanazi, I'm thinking of a stronger word. I think Mr. Maybeck is being very kind to you and your board.
Maybe, Advocate, as you take me through some elements of this settlement agreement, I can explain the thinking at the time.
sorry, Chair, all right. So you accept that it was a complete capitulation?
Complete is a strong word, but I accept that it looked like it was more in favor of Mr. Gama than in favor of Transnet.
Well, could you have done a worse agreement for Transnet?
There can't be a
don't know.
worse, Mr. Mkwanazi.
That would be speculation in 2020. Where are we now? 2020. This was 2011, yes.
Sorry. Mr. Mkwanazi, I don't want to be flippant, but how could you have done a worse deal for Transnet?
Now, when you say a worse deal, you would have to think about the circumstances at the time in terms of whether could there have been a worse deal. The answer maybe is yes. I don't know. That question might be asked, and I might have to respond in writing.
Mr. Mkwanazi,
Yeah.
Mr. Mkwanazi, you called this a settlement agreement, isn't it?
Yes. Yes.
You sought to settle a dispute, isn't it?
Yes.
And that dispute was Mr. Gama's unfair dismissal dispute with Transnet, isn't it?
That is correct.
He had referred his dispute to the Transnet Bargaining Council to try and get relief from his grievance, his feeling that he had been treated unfairly, isn't it?
That is correct.
And if he got what the bargaining council could give him, what he would have called his first prize there, he would have been very happy, isn't it? If he got his first prize,
Chairman.
he had a first prize, obviously. You go
Yes.
to court, you have a first prize. You go to arbitration, you know what you would like to get. If you don't get your first prize, you might have your second prize. If he got his first prize, he would have been very happy. Now, his first prize would have included reinstatement, isn't it?
Yes, Chairman.
And reinstatement with full back pay and benefits. That would have been, I guess, his first prize. Maybe he, well, having looked at his statement that he sent to the bargaining council, I didn't see anything that says he was seeking costs from the bargaining council. It may be that that may have been dealt with in some other document, but that wasn't there. But you gave him much more than the bargaining council could have given him. At least that much you know, don't you?
Chairman, yes, although myself too, I'm not sure now what the bargaining council could have done or whether would the bargaining ruling would have covered coverage of costs, etc. As I sit here, I do not recall the exact documentation that he had submitted. Yeah.
Well, the bargaining council, if it found that he had been, his dismissal was substantively unfair, it could have ordered his reinstatement, which could have meant full benefits and back pay, but it could also have meant he would get reinstatement but no back pay, because it might say it's not as if he was innocent, he had done something terribly wrong, he was admitting. So it might have said no back pay, you know. It might have said not even reinstatement, but maybe should be given some compensation, maybe 6 months compensation, maybe 1 year, but no reinstatement, because it might say this person was the CEO of the largest division in Transnet. He was found guilty of serious acts of misconduct. He admits that he was properly found guilty. This person should not be taken back. Or it might have said, let him go back, but not with full back pay. I doubt that it would have ordered costs, but maybe it would, but you gave him much more than that. That you do know, don't you?
Yes, I do know, Chairman.
Yes, Mr. Maibek.
Yes, thank you. And we'll come to the detail, but why did you treat him so generously?
Chairman, my understanding at the time, as we were discussing this settlement, the other route could have been coming out of that Transnet bargaining process, could have led to further litigation, and I'm not sure in terms of the legal route that it would have taken, but it could have taken quite a long time in terms of settling the matter, and yet the business at the time was not doing that well. Too many acting CEOs, etc. It had its own internal problems, which needed to be tied down.
So do I understand you to be saying that your desire or need to have Mr. Gama back was so strong that you simply paid him whatever he asked for? Is that what you're saying?
Not really. I would have to go back to the history of the documents that were circulating and see what he had asked for. I don't recall, Chairman.
But Mr. Mkwanazi, what you don't see here is any give and take. So when you settle litigation of this nature, especially where someone is accepting a final written warning, and they are accepting that in part they're to blame for their dismissal as a consequence, it's most unusual for the employer then to give the employee everything other than the kitchen sink by way of a settlement. I mean, are you able to explain why you treated him so generously?
Chairman, yes, it might, on the face of it, looks like a generous settlement, but there are some minor elements of it which are not that generous.
Mr. Mkwanazi,
Yes.
Mr. Mkwanazi, sorry, but it doesn't just look like it's a generous. It is an extremely generous settlement to him. I thought you would make that concession at least. It's not that it looks like. It's an extremely generous settlement to him.
Yeah.
Yes, okay, continue.
Why did you want to treat Mr. Gama so generously? Why?
The word generous ignores the fact that when we looked at his legal fees from the two separate processes, that he must be refunded 75%. He still was liable for the 25%. That's maybe on the legal fees. Now, on the other matters that dealt with that settlement, the assumption would have been that if you look at the Transnet remuneration policy or whatever at the time, I'm not sure then what other benefits as this final written warning would have meant in terms of him recouping some of the lost income that he lost due to suspension. Yes.
But Mr. Mkwanazi, let me ask you this way. Why did you capitulate in the negotiations? As you accept you did, why?
Chairman, I don't think it's an easy way to say capitulation. My understanding, he might have been asking for more. It's just that I don't have the audit trail of some of whatever he might have been asking for. I don't have it in black and white.
Mr. Mkwanazi, just that we understand. I mean, you were at the time and remain a very experienced business person, not so?
Yeah.
No doubt you've negotiated many deals in your time.
Yes.
And what we do know is you were the lead negotiator here, correct?
That is correct.
And what we also know is that when you negotiated with Mr. Gama, you did that behind closed doors, one-on-one with him, correct?
There was only one meeting, if any, but I would like him as well at some stage because this thing of these closed door assumptions, it's a long time ago. I don't even recall really if we had that one-on-one, even though I accept that it might have happened. But yeah, let's assume that it did happen. But I hope at some stage he as well will make his own affidavit. Yeah.
Well, the point is there's no one that can tell us why you capitulated other than you, because you brought no witnesses to the negotiations. So let me just refresh your memory. The Denace Rates consultation note of the 22nd of January reflects that after the caucus, you then met privately with Mr. Gama, correct?
That is correct.
Mr. Mapoma's evidence about, and that was on a Saturday, Mr. Mapoma's evidence about another meeting on the weekend at the Inanda Country Club is that he sat waiting while you and Mr. Gama negotiated privately, correct?
Yes.
I see.
Well, Mr. Mkwanazi, I just want to mention something. You said sometime, I think on Friday, that Mr. Gama was the one who came with the idea of having a one-on-one meeting with you. You remember that?
I do recall, and his argument then, that's why this thing happened 9.5 years ago. His argument then was he did not trust the confidentiality of our discussions if there were too many people in that room.
Well, maybe Mr. Mybeck will deal with that in due course. But I think in the consultation note from Denace Rates, either that or another letter or memo, it is said that you said you want a one-on-one meeting with Mr. Gama. That doesn't suggest that you were saying Mr. Gama wants a one-on-one meeting with you. It suggests you were the one who wanted a one-on-one meeting with him. Do you remember seeing that note?
Chairman, I don't recall saying I wanted a one-on-one, but I do recall Gama requesting a one-on-one.
Yes, okay, all right. Mr. Mybeck.
Thank you, Mr. Chairman. So let's go to this settlement agreement, so as to speak. At paragraph 3, Mr. Gama returned to Transnet with effect from 23 February 2011, and he is to resume duties as the CEO of TRF on 1 April. Is that right?
That is correct.
So, I mean, a strange feature of this is that Mr. Gama, he signs the agreement on 23 February, and his duties then resume with effect from that day. That I understand. Then it says, any employment benefits that were due to him for the intervening period, 30 June 2010, when he was dismissed, to 23 February 2011, in terms of his employment contract, will be deemed to be fully restored. Is that right?
That is correct.
So there was no compromise. He didn't give an inch, and you didn't require any compromise. Is that correct?
That is correct.
It's as if you are dealing with somebody that had done absolutely nothing wrong and was just dismissed by Transnet. Somebody who is innocent, completely innocent. You understand that?
I understand, Chairman.
Yes. Mr. Mybeck.
Thank you. Then it says, the full restoration of benefits entails the following. Sub 1, payment of Mr. Gama's short-term benefits which were due to him in the intervening period. Sub 2, payment of Mr. Gama's long-term benefits which were due to him in the intervening period. Sub 3, restoration of Mr. Gama's salary for the intervening period. And then a provision as to where the amounts must be paid. So he gets all of his short-term benefits, all of his long-term benefits, and his full salary. that correct?
That is correct.
Now, if I could just ask you to turn forward to page 80 of bundle 1, 80. It's the last page of the Company Secretary's second affidavit.
Page 80.
And you see at the foot of the previous page, 79, she records the
Yes.
table below as provided by Human Resources provides a detailed breakdown of what was paid. So Mr. Gama got, by way of back pay, full salary of 2.8 million, STR benefits of 2.5 million, LTR payments of 2.9 billion, a Transnet refund saving of some 24,000, and then LTR payments of another 4.7 billion. When you add all of that up, that comes to 13 million. A full restoration of every cent without any compromise on his part and without any reduction having been secured by you during the negotiations. Is that right?
That is correct, Chairman.
And just to confirm, you did all of this because where we landed up in your evidence is that you were convinced that there was a slight doubt that you could lose the litigation.
That is correct, Chairman.
But I mean, Mr. Mkwanazi, that is astonishing. We haven't gone to costs yet, but the taxpayer forked out 13 million here because you concluded there was a slight doubt you could lose the litigation.
That is correct, Chairman.
Does that accord with your principles and knowledge of sound corporate governance?
Chairman, the question of sound corporate governance, what one was trying to do here was to restore to the individual what he might have had this process of that led to his dismissal would have been found wanting or unfair. But then again, based on my submission that this individual would not have been reinstated if charge number 4 of attacking his colleagues had surfaced strongly in the legal advice that one had got then. So all this would not have been paid and all this type of settlement would never have happened.
All right, then, Mr. Mkwanazi, let me also then deal globally with the issue of costs, and we'll come to the detail perhaps after lunch. Could you please turn to page, I want to take you to bundle 2 now, and ask you to turn to page 164.
Okay, I'm being assisted here. Okay. Page 164. Okay. I need to take it out. The writing is quite small here. Chairman, I've got this document, page 164.
Yes.
All right, and that's a schedule in blue, is it right?
It looks like a schedule in blue, yes.
All right.
It is.
Now, if you look, and I'll take you to the detail after lunch, but if you look on the far right-hand side, the last 3 lines of the last column.
The last 3 lines, yes.
What you see is that there were 3 payments that were made to Mr. Gama and or his attorneys of costs. The first was for 1 million or so. the second
Yes.
for 1.7 million, and the third for 1.4 million. So if you add those up, in addition to the 13 million that Mr. Gama got by way of back pay, short-term benefits and long-term benefits or incentives, he was also paid 4 million rand in costs. Do you see that? 4 million rand.
I see it as the document indicates here.
Ah. Okay.
I see it.
I see
Chairman.
you. I see you a little stunned.
Yes,
Understandably.
I am, Chairman.
Yeah. 4 million.
I am, because my interpretation of his so-called legal costs, maybe I don't understand. I am stunned, yes.
But you were the negotiator.
Not
you
true,
were-
but, Chairman, at the time this detail was not in front of me. Yes, true.
Well-
But of course, if you agree on paying somebody 75% or whatever cost, you
Yes.
should have an idea what the total cost would be and what therefore 75% will be.
I didn't have a full picture of it, and funny enough, looking at this schedule from Advocate Mybeck, I see he was paid something on the 16th of April 2015. I do not know what that payment was for, because whatever payment that should have been done, they should have been done in 2011, and no payments should have been done in 2015. I truly do not know what these payments are for.
We'll come to the detail in a moment, Mr. Mkwanazi, but do I understand from your answer to the chairperson's question that when you negotiated and you agreed on this 75% contribution, you didn't even know
Yes.
how much that was going to cost Transnet?
At the time, Chairman, yes, I did not know, because I didn't have the information in front of me.
But that's unbelievable. Are you now conceding before this commission that you entered into an agreement with Mr. Gama when you didn't even know how much it was going to cost Transnet? That's how generous you were. That's how anxious you were to, for some reason, settle with this man. Mr. Mkwanazi?
Advocate Mybeck, I'm there.
Do you want to comment on what Mr. Mybeck has just put to you?
I would like to comment. For whatever reason, I was under the impression that the so-called Gama's costs were far lower than this, and also some of those that were paid in 2015, it's like, I don't know how many, I don't know what they are, but even those that would have been paid earlier on, my assumption was that the people processing, which would have been group finance and group legal, would have looked at the validity of each invoice before paying. Yes.
All right. Well, we'll come to that. Now, let's carry on with the settlement agreement. Back at page 38, please, of bundle 1.
38 of bundle 1. Okay, I think it's this one. Okay. Bundle 1. Page 38. I'm there, Chairman.
Can I ask you, please, to have a look at paragraph 3.3? Mr. Gama is deemed to have served the 6 months final warning. Final written warning. The final written warning will be deemed to have been effective from 29 June to 29 December 2010, correct?
Correct, Chairman.
So by the time Mr. Gama came back into the employ of Transnet with effect from 23 February 2011, this final warning had come and gone.
That is correct, Chairman.
Is that really the best you could do, Mr. Mkwanazi?
In regard to somebody who had been properly found guilty of 3 very serious acts of misconduct.
Chairman, that was the proposals at the time, and in retrospect, it should have been different. Yeah, it should have been different, I agree.
But why were you so weak in the negotiations?
You are chairman of a very large state-owned entity, Transnet. You are chairman
Yes.
of its board. Why were you so weak at the negotiations? Why didn't you say to Mr. Gama, you admit yourself that you were properly found guilty of 3 serious acts of misconduct?
Yes,
Even
Chairman,
if we reinstate you, you must have a final written warning that will start operating when you return. Why don't you say that?
Chairman, I could have said that, but at the time, that's the view that I took. And yeah.
I don't normally use strong language, Mr. Mkwanazi. But what would you say if somebody says this was a nonsensical final written warning?
Chairman, at the time, this was discussed in one of the other committee. We did discuss other types of final written warning, but eventually we agreed on doing it this way.
Yes, but my question is, you are negotiating a settlement of a dispute, a dismissal dispute. The employee concerned is a former CEO of the largest division of Transnet. He has been found guilty of 3 serious acts of misconduct. By this time, he accepts that he was guilty of these. Now you are saying, okay, we will reinstate you, but there must be some sanction for your misconduct. I take it that you must have said, or when you spoke about a sanction, a final written warning with Mr. Gama or his lawyers, you must have been talking about a final written warning that would be operative when he came back and would be operative for 6 months. You were not, when you started talking about it, you were not talking about a warning that would have expired by the time he came back, were you? When you raised the issue for the first time, because I assume it came from your side.
Chairman, it was debated in one of the subcommittees, and I will now put some other thinking of what maybe could have swayed that subcommittee to look at it this way. Maybe it was to try and get Mr. Gama back and almost operative from day one, so that he doesn't sit in such a key position with the final written warning on his.
But Mr. Mkwanazi, if he deserved a final written warning, it should be there when he comes back. How can you say he should not sit there with a final written warning? That's what happens with every employee. Why should he be treated differently?
No, Chairman, I understand your anxiety.
Actually, you should be stricter, shouldn't you, with senior people than with junior employees? Because senior people can't plead ignorance. They know the rules, they know the policies. They are supposed to be exemplary to the junior employees. isn't it?
Chairman, I agree with you fully.
So I come back to my proposition or my question. What do you say if somebody says this final written warning that you agreed to as the chief negotiator for Transnet, for Mr. Gigaba, is a nonsensical final written warning? Because it is February 2011 when you are negotiating and you are agreeing to as an arrangement in terms of which Mr. Gigaba will be deemed to have carried this final written warning from end of June 2010 to December 2010 when he was not at Transnet. What do you say if somebody says it was a nonsensical final written warning?
Chairman, I concede, even as I read it, it does not look right, Chairman.
Yes. Mr. Mybeck?
Mr. Chairman, I see that it's 1 o'clock. Would this be an appropriate time to break for lunch?
Yes, let's take the lunch adjournment. We'll resume at 2. We adjourn.
Mr. Mkwanazi, the chairman have left the chamber. You